Good afternoon, good evening, good morning, good, as we say in Denmark, good behind, good weekend.
Goodbye.
Yeah, we're weird people. I don't know. You might have figured it out.
I love it.
After watching your stream with leg workouts and crime spies experience with kettlebells, I got a video called The Optimal Way to Grow Huge Glutes and Legs with Only Dumbbells. Well, the algorithm doesn't listen at all. But yeah, grow your glutes. Do a ton of Bulgarian split squats. All the ladies do that at the gym. A year ago, it was pistol squats, and before that, it was kettlebell squats, and before that, it was donkey kicks. None of that heavy squat because it helps, but it's not as fun. It doesn't look as good on Instagram, and it hurts our little back when we have to put the bell on the barbell on your back. So better to do something that doesn't work but looks good on Instagram. Buongiorno, Madame Crime Spies. Welcome as a new person. I'm speaking wolf. Little Peanut, how you doing?
Oh, little Peanut. I've missed you.
Ralphie. Danny T. Hello, little muffin Danny T. And Haley Wolf. I'm talking wolf to her too. Hey, Stace.
Goodness.
Good afternoon, Iris. I hope you had a nice day. Now you didn't have to be angry at me for doing a surprise streams. And Irish also. And Leslie Moore. Oh, nice to see you. Cool gamer. Hello. Strong intro. It's always strong. It's probably what get me in trouble with monetization, according to Shizzy. I don't know why. Nope, still green. Who goes there? Crime Spies. Hey, Farrell, how's your facial?
Oh.
Hey, Liz, welcome. And Brian Fitz. Hello.
Hi, Brian.
We embrace the witness. Exactly. Hey, Peter. Peter sleeps less than I do.
Aw, Peter, how are you?
Hey, Hottie, how you doing? Had a tire blowout.
Woo. Tire blowout.
Yeah, I sometimes get tired when I have a blow. Hey, Sean Bird. And Christine, how you doing? Grow the guts. Yeah, I'm not for a six-pack. I'm more of a keg kind of guy. You were over and recovering before he went to lodge. He gave you lots of praise and a shout-out. Well, he's a nice guy, and thank him so much for rating me yesterday. Maybe I can return the surprise. It was so lucky that I called it before I ended my stream. But he's a nice guy. I like him. And he has a very, very good internet voice. Cindy Lou. Woohoo. MLS gives recovering addict a rate and recovering addict takes up. Yeah, well, you know how it is.
He rated him this morning. And he was talking about Baker.
Yeah.
That's funny.
It's because I'm a nice guy. Food Fairy, how you doing? Old Line Red is here as well. And Rossman Rans. I don't know why I wanted to say clippity, clippity, clippity. Because it's not a horse, it's a mule. You are so ready for me. Well, I can make you more happy because I just had my ESTA approved, so I can legally travel to the US now. I don't have to go over the border on my walking feet. I can fly in now. Hey, Sue, how are you? And Erin Hack, I just saw you over at Tom's. Yeah, as she says, if there's a live feed from the Karen Reed hearing today, we will jump over there. It's supposed to start at 3. We will keep an eye on it because Mr. Tucker will probably waste everyone's time again today talking about anything that has absolutely nothing to do with his case. So we will be covering the Karen Reed, and I'll begin early tomorrow if he drops a bombshell and wins his case afterwards. What is going on with? I don't know. But if it's going on, keep on going, go on. Hello, Shanachey, Rhode Island. Well, thank you so much for stopping by. You're new from Turtle Boy. Yeah, and the Canton 8 was in court this morning. I had a family kind of emergency, so I haven't had time to follow along with Tom all day. I hope it went well for them in court today. Souter, how you doing? Iris, we talked about this. We changed our tone at New Year's. This is a good, well-behaved stream now. We don't use that kind of language. Well, it's probably cold where you are, so sit in the car and get someone else to do it. La 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 la. Ba-ba-da-ba-ba-ba-bum. Hello, Shanachey again. Recovering addict is in your neck of the woods, a little north. I don't know where it is. Were you on the experts panel? Nice. I didn't watch it. I slept all night. Well, I didn't sleep all night because some guy kept me up and got my blood pressure to 200, so I didn't get out of bed till 8 this morning. So that was nice. 7 hours of sleep. Treehouse, Frank's wife was on recovering addict on the phone. Oh, yeah. That's the worst part about having family emergencies. You miss a lot of all the cool stuff happening. Salutations, greedy bloke. Because you have me, who brought up the fact that you introed me to his stream?
I don't know what's happening.
What she's talking about?
I don't know.
Is she going to yell at me afterwards?
Probably. Be careful.
Good, Iris. Hey, Erin. Olivia, how you doing? Wicked Psych. Oh, so glad to see you. And Scott McGinnis, one of my favorite peeps. And that's people. It's street slang for that.
What is it called? Your East Side Posse?
East End Posse. Oh,
East
as my
End.
friend, as my friend tagged it, Est, because he couldn't spell East. Carlene, good afternoon. Thank you for stopping by. Your Swayze is on point. It is. Talking about Swayze. That little thing that all of us should have.
Okay. Do you remember any description as far as the size of these men?
Yeah, I remember the size of them. I know, I could tell by the Swayze who the one was, by meeting him different times up there at Paula's. I knew Swayze is, get that word right, Swayze?
Okay. I don't know what that word means, so I'm sorry.
Oh, his style, his walk, his talk.
Okay.
John, there was some other things that the judge had to take care of this morning, so they should be starting now. Having lunch between protests. Well, as long as you don't protest your lunch. Before I go, how are you? Yeah, we are in great shape. Jamie had the morning off. She's ready to go. She's firing on all 12 cylinders.
Am I? Oh.
Exactly. Tooth Fairy, how are you? I have a certain... Well, I just hit the gym after I had that family thing. So, and it was filled with all of these... I hate January. And they were looking funny at me because an old fat guy coming and putting his straps on, and they were like, And then I had to sling some weights around. show all the young kids who's still the alpha, because I know that's a thing. There's two things that you must be on YouTube: an alpha, and you must be in some kind of beef.
Sounds about right.
Turn in on Sunday for the Baker's birthday beef bash.
Hmm.
Tracy Violet, oh, amazing to see you. Exactly, my birthday beef bash on Sunday, and I'm turning 27, so you're all invited. I might even eat a cake. Oh, thank you, Iris. Now I understand. I'm not that smart. During cancer now on advertisement. Okay.
Franklin Tucker, case 17, CF 841. Let's see, prosecutors are here, but I don't see Mr. Tucker.
Oh my God, no.
Some word from the front door.
4 days in a row, this guy is late.
No, Judge, we have not received anything.
And he had the whole morning.
Yeah, but his Lyft drivers doesn't understand English.
We're at the point where we're ready to ask for cases.
Yeah, I'm almost ready to issue it.
Our witness is here.
Have a great day in Dedham. Hey, Kim, how are you doing today? We're missing a defendant. Oh, let the police get him. Put him in prison.
I think it would be funny at this point. Like, what is wrong with you?
She's out a solo gym in my town, and I'll show you. Baker birthday, exactly. I will not be in my birthday suit.
Why?
The jurors are in the jury room.
Well, that's a
Yeah.
lame birthday.
I think I can buy some frozen cheesecake. Maybe I should try that for my birthday. Ruining
Oh,
it.
God.
Well, yeah, it looks like vomit.
115. And if he
Yep.
arrives beforehand, then
He's late again because no better way to get under the judge's nerves.
This
He's
man.
such an idiot.
He is such an idiot.
Yeah. Yeah, Ashton Kutcher will be come running into the courthouse saying, "Hey, you punked." Yesterday he was just about to order the police to go get him when he arrived at the court with his hands in his pocket and his shades on. Because that's the way you should do it. The judge won't lose his proverbial when you do that. 4 days in a row. Yeah, let's get Cackerberry after him.
That's a good one, Iris. Yep. I'm convinced he didn't do it. There's no way he would have showed up on time.
I know Dedham is in Massachusetts. It's where the courtroom is, where Karen Reed is going to be today. I know that. Yeah. He walked in 5 minutes after with shades on and thinking, oh, we were supposed to rob this place. I'll see you later. Bye.
Okay.
It's a Zoom hearing, but still going to be in front of the court. Yeah, I know this, and I saw the Zoom link was out there, but the last time it was filled, so I'm not trying to get in on the Zoom call. I hope news stations will carry it.
I can't imagine they won't.
Well, at least here it's just a dystopia. We're not socialist or liberal. We're just anarchy. Yeah, it's a total disrespect for the court, and he should be turned around. They should lock the door. I know. Well, he has the right to. No, at some point you forfeit the right because he has been admonished 3 days in a row, and he still does it. Well, my Lyft driver. Yeah, Zoom number was out on Facebook. That's why I think you won't be able to get into that Zoom meeting, and it's probably going to be on another Zoom call. I'll take the anarchy. There's approximately 25 business days until Karen Reed trial. Do you think the prosecution will turn over the evidence the defense is waiting for? Well, they will. I don't know what Massachusetts rules are, but they need to give them ample time. And in some states, ample time has a deadline. I think Dave told us it's normally 10 or 14 days. But ample time is ample time, and if they feel like 2 days are ample time, they can turn it over 2 days before, but they will probably, and again, they have been ordered multiple times to turn over the stuff. But I hope this hearing today gets the last of the stuff out there. Well, it's just so stupid to drive the judge to a breakdown, because the judge could have helped him if there's no evidence of the crime presented during the state's case. The judge can say, well, you're free to go. Now the judge will, any morsel of evidence will be counted against him. His dog ate his brief. Yeah. That's probably the problem. Hello, Fedorowski. Jamie is having her last day today. So hopefully this farce of a trial will end early and Karen Reed will go quick, so I can hang out with Jamie before she goes, because tomorrow we won't be able to recognize her. She will be all luscious and new. At some point, if they don't release discovery, the judge can just exclude the evidence. Yeah, but again, you have the ample time frame. That will probably be 14 days. And I have an idea with that state, they'll just drop everything at once, like thousands of pages. Oh, movement in court. 8 minutes late.
So I see you've graced us with your appearance, Mr. Tucker. Where were you when the case was set for 1 o'clock?
I was again on my way here, Your Honor. You know, again, I'm not the best judge of the traffic and everything in the U.S. anymore. Apparently, I don't.
Then you are there 2 hours before, you stupid.
I haven't been able to judge. I was actually planning on being here early today, Your Honor.
Well, this is the last time, sir, because next time I'm going to issue a capias. You will be taken into custody, and we will then know where you are, because we have 14 people who are here on time, 2 more over there, 1 more over here. These people, for about the 6th time, we've sat here waiting for you, and it now is interfering with the orderly process of this trial. I have been more than indulgent with every step of the way in your plodding along and showing up late and your cavalier attitude. Be warned, next time I will grant the state's motion for capias, and we won't have this problem anymore.
No, he's going to argue.
There's nothing need to be said other than if you need to leave earlier, whatever you need to do, be on time.
Yes, sir. Yes, sir. That's all I want to say. Yes, sir.
Mm-hmm. So
Did he have an excuse?
we're back. And
Yeah, he's not a good
Mr.
judge
Johnson is here.
of traffic.
Okay.
You could just see his face. I want to argue this. No, shut F up.
You're
And it's at 1 o'clock today.
you had all day to prepare.
Thank you. Okay, Mr. Johnson. It's afternoon.
Yeah, it's the 6th day in court. He should know traffic is hell.
So we're back here in trial in State versus Tucker, 17 CF 841. You're back on the witness stand. We're going to bring the jurors here in a moment. I just remind you, you were sworn to tell the truth.
Are you getting a lot of snow
yesterday,
too,
and
Fed?
that oath
North of Jutland is
remains in
getting a lot of
effect.
snow, and apparently Shetland is
All right.
too.
Bring the jury in, please.
Yeah, he's going to revoke his bond if he doesn't. He'll going to be late again tomorrow. I hope they throw him in prison for the weekend.
I know.
Yeah.
At this point, he deserves it.
Yeah, he's just an idiot. He's a big idiot. And again, his stupid mouth will put him in jail. That's my best opinion. Snowed since yesterday afternoon. Well, we just got a little dusting 2 days ago, but supposedly we're going to get a lot tonight.
Snow?
Yeah.
Ooh.
Well, she called into a recovery addict and spoke with him. Oh, I'd like to have like a call-in show.
Yeah.
I don't know how you do that. Have some weird people.
One more? Okay, well, you folks can have a seat while we're waiting for.
I think it's one of those
join us from the jury room.
those glasses who no, because it's inside, so he should have. They should have turned.
He related to the expert. No, I think he has the transition
Okay,
lenses.
thank you. Everyone can be seated. Good afternoon, members of the jury. Good to see you all here today, albeit
If he's
the
late
beginning
tomorrow,
of the
yeah.
afternoon. As I told you yesterday, I did have a docket this morning, and we did accomplish what we needed to with those other cases. And so we're prepared to continue where we left off in State versus Franklin Tucker. The witness, Mr. Johnson, is here. He is still under oath, and we're going to continue with the cross-examination.
Thank you, Your Honor. May we approach the sidebar?
Yes.
Sidebar to begin with. Why didn't we do that before the jury was let in? 8 minutes. 8 minutes. And as my old boss said, if you are less than 45 minutes late, you're just taking the S of me, because then you didn't oversleep. You just didn't get out of bed. So he was more angry if you were 5 minutes late than if you were an hour late and he had to call you and say, hey, you had to be at work. Sean Bird, I won't eat a Snickers bar because I'm not me when I'm not hungry. Hey, Danielle, how are you doing? Yeah, he keeps pushing. He's turning into a lady in labor. And he's going to do something stupid again today with the videos, and we're going to have to argue for 20 minutes. And, Scott, you and me both. Because he's taking the mick out of it, and he could have gotten away with 2 years for a murder trial. He's going to end up in prison. I bet you. Don't you call me a fussy. He's still with power, but he's okay. Good to hear. Thank you, Iris. Bum, ba-dum, ba-dum, bum, ba-dum, 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 bum, ba-dum, bum. It's so bad at my gym. They've started turning Bruno Mars songs into elevator music. It's so annoying. You're standing there and it's da 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 da, and you're thinking, "What's that?" And I know that song somewhere, and it's Uptown Funk. in a jazzy version. It's annoying. Shorts again. Yep. Pants are prison. We need shorts. Do your thing and put me to sleep. I'll do anything to put you to sleep, Farrell. Even give you a facial. Fedorowski, yesterday we spent like 4 hours arguing about if he could bring in some video, and when he brought in the video, we spent 4 hours trying to impeach the witness with stuff he actually said. And he said, "Oh, did you change your story?" No. But on the tape, yeah. And I said it right after this. Play the next clip. Yesterday we lost everything for him. Maybe. Phrasing, Farrell. Phrasing.
Mhm.
Yeah, if you're having the strap on the back, make sure you don't have to have it tight, but just make sure that it's together. Yeah, if you had been there on time, your computer.
Your Honor, I've talked to the state, and apparently the rest of the video that we were watching, they believe, I believe as well, it's mostly, mostly not more interviews. It's mostly, just Mr. Johnson sitting in the interview room, which I don't think would serve the jury very well. So we're going to go ahead and forego the last, I think, 10 minutes of the video.
Okay.
Well, none of it's serving the jury very well,
Okay,
sir.
in that case,
No.
I think
Why did you ask about it yesterday? What happened yesterday? Fed. Don't play with my emotions today. I'm quite. My emotions are raw today.
Aw.
Yeah.
Okay, Mr. Johnson, let's see if we can recap a little bit here. Now, we went over your interview with Captain Phelps, pretty great length.
Oh, that was on
couple of
Dave's
things I
channel.
wanted to go over before we go ahead and excuse you. Now, you did say that you didn't go anywhere else prior to the treehouse that day and the beach. Is that it?
As far as I can recall.
17th, right?
As far as I can recall.
As far as you can recall. You don't recall going to CVS that night?
I do not.
And you said you would be surprised to learn if they had a picture of you outside of CVS. Is that correct?
Did you show the picture yesterday? No.
You haven't.
And show it today or get all.
Remember, don't know about the picture they took it. Okay. Would surprise you to learn that that's actually just prior to the incident going down, and just prior to the crime.
Yes.
Now,
Not surprised, yes.
okay.
Mr. Johnson, could you keep your voice up, please?
Yes, sir. I apologize.
And let me go ahead. Yeah, apparently the mic didn't have a battery yesterday, so I want to make sure everybody hears me loud and clear today. Mr. Johnson,
Thank you
if
for your.
again, you saw a picture of you outside the CVS, I said, if he saw it,
Okay, let's hear the question. So go ahead.
just prior to the crime taking place, what would that picture mean to you?
I don't know. I don't recall it. I don't recall going into the CVS.
Oh, you
You
don't
said
recall?
that a million
What I
times.
asked is, what would that picture mean to you?
What would it?
Did you say yesterday? I seem to remember you saying something like, get a
He's
lick
already
or
getting on
something
all
like
my
that. You
nerves.
described
Hey,
to us
Stephanie.
what that
All
meant.
of them. Every single
Getting a
last
lick,
one I
that's
have.
what it was.
Yes, I described that.
GG.
Okay. And what is hitting a lick again?
As far as the
Hi, Kiki.
vernacular, as I understand it, it means to
4 hours?
steal something, to take something, to come up from a broke position.
Okay. And is that criminal terminology?
It's a
Thank you.
vernacular, slang vernacular.
Okay, but is typically used in criminal terminology.
I
Getting
wouldn't know if that was what that was in reference to or not. No, that's just slang as I understand it.
Okay, but you understand it as a come up, right? To get something.
I believe I explained that, yes.
Okay, good. Just making sure we're clear. Now, do you understand the vernacular of casing a joint?
Yes.
Okay. Do you understand how a picture of you in CVS just prior to the crime could be considered casing a joint?
No.
8 minutes
I'm
late.
going to sustain the objection. Sheer speculation.
No. Mr. Johnson, again, you also said that, what is it? Let's take a look here. Make sure I'm correct, because I may not be. Let's take a look.
You're probably not.
No.
You
said
had-
emptied your truck, correct? As soon as you got up to
All day to
time.
prepare.
Yes.
This
All
is
day.
when you discovered your footlocker.
All day and all morning.
I didn't discover my footlocker.
No, somebody put something into your footlocker. I'm sorry.
After
Let
I
me-
emptied my contents in my truck into the
It's a-
residence where I was residing, yes, this is when I discovered
Okay.
the backpack in my footlocker.
Backpack in your footlocker, and you have no idea how it got there.
No, I don't.
I don't think that picture exists.
I hate when he kept saying, what would it mean
And when
to
was
you?
this footlocker?
Yeah.
I don't know what this picture is.
Several times.
The judge said, if it happens again, we will put you in jail.
Did you you said that I helped you put your footlocker into your truck. Do you remember what date that was?
The date that I left.
Okay. So
Are we supposed to
would've
get
been
snow
on
tonight?
what, 22nd? Oh, I'm sorry, no, it wouldn't have been on the 22nd. That would have been on what? Yeah, that would have been on the 21st. Is that
Jamie, can you call
Sound
court and
about
make
right.
it stop?
That sounds about correct, yes.
correct? So you said the day of the raid, right?
The day after, like the morning after, yes.
Morning after, so that would have been the 22nd. I'm just trying to keep our timeline. Okay, so 22nd is when you moved, and supposedly I helped you move this footlocker. I seem to remember, let's see, let's go by my memory. Now, after the raid, I wasn't there, correct? I was at the police station.
I guess they took you into custody, yes.
Okay. Well, actually, you wouldn't have known where I was. That's true. Okay, so but I wasn't there, right?
Not when I got back, no.
Okay, and did I arrive sometime later,
Early this morning,
early that morning? Do you remember about
He
what
should
time?
be able to.
before sunrise.
Before sunrise. And do you remember me saying anything to you after I got back?
No.
Don't remember anything.
No.
Did I have to wake you up to open the door?
No, I don't believe so. I don't remember.
You did have the only key, correct?
No, I didn't.
Well, you said Rory Wilson had a key.
Yes.
Okay, but Rory was, to your knowledge, was Rory Wilson, man? Was he actually still in jail at that point?
Yes.
Okay, so he did, and obviously his key would probably be there with him, correct?
I don't know.
Or again, would I have access to it? Most
I
likely.
don't know.
Actually, let me rephrase this. This is too much supposition.
I thought we covered this yesterday. This is all repeat testimony.
Well, I can't
Yeah,
say
move on.
with
Please
certainty,
move on.
So we certainly
Thank you.
aren't going to cover what has already been asked and answered, but
Right.
thus far, I can't say with certainty that's the case.
Thank you. Let me go ahead and get this a little bit better.
But it's still not relevant.
Want to do that. Let's go here. Okay. Let's see what we got here as far as weekends. Okay. We've already covered the routes. We've already covered
What the?
the knowledge. Okay.
He has nothing on his screen.
Do you happen to remember?
He
your
has
phone
Google
number
search bar.
from that point in time?
I do not.
Okay. Again, did your lawyer, again, make you privy to any of the discovery concerning phone records?
No, not concerning phone records.
Okay.
He's
Now,
going to
in the
Google
video, we
something.
did see the detectives, if I remember right.
Oh, this is so stupid.
I would imagine you saw with us the detectives discussing.
He's
their
going to
phone
Google
calls with
something
Roy
stupid.
Wilson.
Yes, I remember that.
Okay. And they discussed how your phone calls were right around the time of the crime, correct?
I don't remember what time the phone calls were. No.
Okay. You don't remember when you watched the video,
Ay,
what
ay,
times they were talking?
No.
ay, no me
I
gusta.
would surprise you again. I think you said your answer. I'm trying to clarify here because my memory may be messed up. I think you said that you told the detectives. Did you tell the detectives something like we were just talking, we're just talking or something like that?
Again, I don't remember the conversation.
Okay, not even after the refresher we had.
No.
Okay. I don't know if we want to go and repeat the video, but
Nope, we don't want to do that.
We may have to.
Nope, we don't need to do that.
Now let me converse with the state, if you wouldn't mind, for just a second.
But he makes it again. You had all day to prepare for this. You were late for court, and you open up a Google search page. And now you're going to go back to the video we watched for 4 hours yesterday where you couldn't impeach him on anything. La, da, 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 da. I know I got my Esther today, but I'm not sure I'm going to make it to the US because of this guy. Well, I haven't watched because he has the confidence and thinks he's on the right track. So I haven't watched that, but I watched Brad Leon. He had standby counsel, and he tried to object to things. He tried to do the legalese, not like Darren Brooks who just yelled, but Brad Leon kind of tried to do the right thing, and then he did the best thing ever. He introduced Exhibit 100. You can't get away from the EU. Yeah, pro-CA idiots. Well, but normally they don't have this amount because he thinks I really believe he thinks I got this. Again, abracadabra, this case will go away. And now he'll get, I don't know how long, 20 years in prison because he's an idiot.
Let's try this again. Mr. Johnson, do you remember watching the video yesterday?
Yes.
Okay. Do you remember the section where the detectives are talking to you about your phone calls with Roy Wilson?
Yes.
Okay. You don't remember the context of that conversation, or do you remember what you said in that video?
I don't remember what the phone calls were about between me and Rory Wilson. And I do remember in the video me saying the same thing.
Okay. You saying the same thing in there?
Yes. But I don't remember what the context of the video, of the phone calls were. I still to this day don't remember.
Okay. But you do remember the context of the video, right?
Yes, of course.
And you do remember the detectives asking
Trevor Summers?
again,
I don't know that.
asking you in reference to the time frame of those video or of those phone calls.
Yes.
Okay. And how it is around the same time of the crime, before and after.
I remember the video, correct? Yes.
Okay. So you remember them saying that?
Yes.
Okay. Good. Okay. And now you said that you were in a hurry to get out of there, right? You wanted to get out of the warehouse, get away from myself and Mr. Wilson.
Yes, I said this.
Okay. And so you were in a hurry to get out.
Hey, Libby.
My understanding of the word hurry is to move as quickly as I possibly can.
Well, then you agree on that. What
Right.
would you consider as quickly as you possibly can, considering that, again, you had learned that it was a homicide?
The time frame references between here and now, I really don't know how to answer that question for you.
Okay. Would you consider, again, you said you left the crime scene because you were scared and wanted to get away from the situation. I'm asking you, how quickly would you want to move out of the warehouse where you were still being subject to myself and Mr. Wilson, still being there?
As quickly as I could.
Okay. And as quickly as you could, would that mean a week, a month, a year?
Unfortunately, I'm not a fortune teller and I can't see the future, so I have no idea how long it was going to take me. I had no clue how long it would take me, and I had no specific time frame.
I think he ate another
to how
thesaurus
long
and found
my
another
hearing
word.
should take.
Jamie, I need a
sorry.
bio break. Sorry.
Okay, would it surprise you?
Go
that
ahead.
The day after the crime, you had about 10 phone calls with Mr. Wilson?
No,
Okay, doesn't surprise you.
no, I don't remember these phone calls.
Okay, you don't remember those phone calls.
No.
Okay. Again, you moved out, was it the 22nd we agreed? Okay, so the 22nd, so the 17th to the 22nd, that, you know, my count, that's what, 1, 2, 3, 4, 5. So you 5 days and
Right.
you moved out, correct?
Oops.
Correct.
Okay. And what were you doing in the meantime?
What people do to try to get out of where they're at.
Okay. What did you do to try and get out of where you were at?
Scheduled appointments with individuals that my girlfriend and I could acquire for me to get work, perhaps shelter,
Okay.
residence. These things take time.
I would understand that, and under normal circumstances, yes, that would probably be the case.
Normal
What I'm asking you is
circumstances.
under the stressful circumstances that you were in, does 5 days seem like a long time?
This has already been, we've already gone over this multiple
Okay.
times. I'm going to sustain.
Move on, dude. Move on.
Again, how many conversations did you have with Rory Wilson after the crime?
I don't remember.
You don't remember? Do you remember any? You don't remember talking to him at all?
No.
And, you know, let's see. You did, you know, you said you didn't see Rory Wilson after that, though, correct?
Okay. What?
You didn't see Rory Wilson after the crime.
Yes, I did. I
Oh, I'm
walked with
sorry.
him back from Tom Thumb.
Walked back with him from Tom Thumb, spent the night with him there, correct?
Yes. The next few nights
Partying.
until the raid happened.
A
Yes.
second, partying, correct?
For one night. Yes.
Okay, and does that seem like the actions of somebody who's scared?
Do you understand what the actions of somebody who's scared are?
You have to just answer
I would like
the, not with the question.
I
So
don't know how to answer your question. Yes,
that's
no,
all you need
yes.
to- All you need to
Yes.
say, if you don't understand the question, you don't know how to answer it,
Well,
just say that.
I'm just
Yes,
trying to
Yeah, we
understand.
know, so let's just go on with between the two of you, question and answer.
I'm
That's what
trying.
we want.
I would like to understand, Mr. Johnson, why, if you were afraid enough that you took off and, you know, left the crime scene the way you did, that you would sit there and party with these people when you got back.
Yeah, I'm going to sustain the objection.
All right, so we established that, you know, the very first, you know, the crime afterwards.
I'll overrule that, but
Okay, thank you. All right. Mr. Johnson, okay, after the partying of that night, again, did you see Mr. Wilson after that?
I saw him up until he was arrested at the raid.
Okay, you saw him up until,
Periodically, like coming and going, yes, as well as you.
did you have any conversations with Mr. Wilson?
In passing, I don't remember specific conversations, no, but I'm sure that we spoke.
And you said that he held on to some of your belongings for you while you were in jail. Is that correct?
I said that he said that.
Okay, and did he in fact hold on to some of your belongings while you were in jail?
If you want to call it that, yes.
Okay, I don't know. What would you call it, Mr. Johnson?
It's all semantics.
I know.
Theft.
So you're saying he stole from you while you were in jail?
That was my belief, yes.
Okay. And again, you know, did you inform the police that he stole anything from you?
Be right back.
This is what I informed them that could have happened. I don't know if it was him or not.
Okay.
The investigators are the ones who were determining that. This was the only information that I could give them, is what I believed.
This
and
is
what
my
he
big
told
problem.
me,
All of this
and
is
where
so
my
what?
belongings were. This is what I told them.
And you told this to the police
Oh,
when you filed your
go hit
report
the gym.
for robbery, not
That
after,
day.
not after
The day it happened, with the individuals, the officers that came when I called the police. That's who I told this to.
and you told them that Roy Wilson stole from you.
I told them I believed that the individual on the steps stole from me.
Did they question Roy Wilson?
None objects to the relevance of this line of question.
I'll overrule the objection.
Thank you. Did they question Mr. Wilson at all?
No,
Okay, they didn't question. And did you in fact ever get any of your items back from that?
no. Not the ones I reported stolen, no.
Okay, but that was the guys they used when they brought you down to the station, correct?
Correct.
Okay, but you didn't get any items back?
No.
Okay. And you said, again, that you emptied your truck. Okay, when they went to search your truck, if you emptied it, why would there be items still left in there?
When my truck was searched by the police, this was months after I had been arrested. Months after I had been arrested. My truck had been towed from said residence and packed by whoever didn't want my stuff in their home anymore into my truck to have it towed to Mr. Martin Ochoa's residence. That's where the search was conducted, not at the time or point of my initial contact with police.
So to be clear, just to be clear here, your truck got towed from the residence you were at to Mr. Martin Ochoa's home. Is it a home or is it his business or something?
His home.
His home. Okay, so it got towed to his home with your belongings in it, correct?
Yes.
Okay. And you said this happened, the search happened months afterwards.
Yes.
Okay. Now, did anybody else, to your knowledge, have access to your truck at that time?
Everybody that possibly wasn't me. I was in jail.
Okay. Okay. When the tow truck actually took it, did you have the keys, sir?
The keys were in my property. I did not have them, no.
You didn't have access to the keys?
No.
Okay, so that would mean the police had access to the keys or somebody else.
They were in my property.
Okay. And we did have the privilege of talking to former Detective Malone, who conducted the search on your truck. I think she described it as a lot. Does that sound correct to you?
A what?
A lot. You said it was Mr. Ochoa's home. She described it as a lot. Was it a lot?
I don't know. I've never been to his home.
Again, it's semantics.
Did you
It doesn't
ever
matter.
find out
It
what
has
happened to your
nothing
truck
to
after
do
the
with the
police
crime or who committed the
It was repossessed by
crime.
the bank.
It was repossessed by the bank. Okay.
Correct.
Okay. So you have no idea what happened to it after that.
Correct.
Okay. Now, again, amongst your belongings that they brought out in the search was, I believe, an extensive knife collection, if you want to call it that.
Yes, it was.
Extensive. And if I seem to remember correctly, you like to take care of your knives. Is that correct?
I'm a blade collector, of course. Yes.
You're a blade collector. Okay. And
We
you
talked
like
about
to
this
sharpen
yesterday.
Your knives and oil your knives and such things. And again, I'm not a very
Hey,
again, I'm
JMS
not a very
978.
knowledgeable person in this thing, but I seem
Stay
to
warm
remember
if you're out
that was something
on the
you liked.
streets.
Is that correct?
Yes.
Okay.
They are thinking,
And
why are we
would it-
wasting another
would it
hour
surprise you
on this?
to know that the residue from those things can be detected?
He's not a crime scene
Oils
investigator.
The stone,
The stone.
and when you sharpen the blade.
Yes.
Okay.
I guess.
Okay. Well, again, now you said that the knife that has been used in this crime, you said that belonged to me, correct?
No, I did not.
I seem to remember you. Who did it belong to then?
I don't know.
Okay, you don't know.
No.
Okay. Okay. I'll save that one for redirect.
No,
And
he's
again,
just as
the
bad
knife
as,
seemed to
but
have
again, being just as bad as
great detail.
bad
in
lawyers doesn't
describing
make him good.
In your interviews, how familiar were you with that knife?
Familiar enough to think that it was a dive knife.
to think that it was a dive knife? Did you know the color? Did you know the handle? Did you know the blade?
Yes.
Okay, all of those things.
Yes.
Okay, and again, how many times have you been in contact with that knife prior?
Once.
Once?
Yes.
Okay. And how long a period of time were you,
Don't recall.
Wait. Let him finish the question.
how long a period of time were you in contact with this knife?
I don't recall.
You don't recall, but enough to know the details of it, correct?
Sure. I'm interested in knives. I try to remember them.
Okay. So, but it doesn't take very long.
No,
A cursory glance, maybe.
it depends.
Okay. Let me go ahead and we're going to go ahead and subject the witness to recall. I'll go ahead and we can end this and go for redirection.
Oh my God. Recall.
Well, when you say subject to recall, you're talking about in your case? Is that what you're
Yes,
saying?
yes, sir.
Mhm. Well,
Why?
I guess the cross-examination
Why?
is concluded.
It's concluded.
So state would like redirect examination?
Jamie,
What?
you know I love you.
What? What?
Why? Why do you make me do this?
Because it's fun.
Okay.
And you love
Before I
hanging
get
out with
started,
me.
I do want to move into evidence the video that the jury watched during the cross-examination. I have it marked here.
Well, he's gonna recall him in his case, maybe.
Yeah, but the judge should be like, you should do your cross and be sufficient.
Yeah, be done with it.
And be done.
Yeah.
Someone's got it. Okay, I have it marked as P as in Papa.
P as in
Take a look at
Papa.
this.
I take it there's no objection?
No, sir.
All right, admit as the state's next in order, number, what is it? Third? I thought you already had the third. I thought we were up to 15. All right, admit state's 15.
All right, number 615 is in evidence. I'll be referring to some portions of the jury correct, Judge. That's why I want to make sure it's queued up. All right, Travis. A couple things I want to clear up here.
Yes, sir.
Watch how it's done, Tucker.
You said way back in the beginning, you said you came to Key West, you actually advertised, was it on Facebook?
Yes.
And you advertised for what?
For a position as a painter.
Okay, and did you receive calls through that advertisement?
I did.
All right, can you say for sure whether you did or did not receive a call from this defendant during that early time in Key West?
I cannot say no.
Is it possible you received a call from him not knowing who he was or not knowing what your future with him would entail?
Possible.
Okay. So the first time you remember meeting him is when?
When I got out of jail.
And you were living at the warehouse?
Yes.
And when you first met him, where was he?
At the warehouse.
Was he with anyone at the time?
I was with Detroit Wilson, Rory Detroit Wilson.
And that's the other one that's involved in this plan this night of this
Correct.
robbery. Now, Travis, you agreed to get involved in this, I guess, this plan, and your expectation was to what? What did you expect to get out of it?
Gas money for my truck.
And at that point in time, are you familiar with the legal concept of the principal theory?
At this time, no.
Did you know that you could potentially be held liable for anything that happened inside of that treehouse, even though you were only the getaway driver?
No, sir, I did not.
Now, the plan, to be clear, was to go in there to commit a robbery. Is that right?
Correct.
And again, what was the goal in going into that treehouse that was discussed between you, this defendant, and Rory Wilson?
To get the money in the crack that the resident had.
And again, that lead came from somebody at the Burger King. Is that right?
Correct.
Now, you said several times that lead was brought back from Burger King by Rory Wilson, right?
Correct.
And then at one point, I think on one of the tapes, you said something about Tyrone. Is that right?
Correct.
Was that a misspeak on your part?
Yes, it was.
as you sit here today, do you remember who brought the lead back to the
Yes, I do.
to the warehouse?
I do.
And who was that?
That was Rory Wilson.
All right. He brought the lead back, and who did he share that lead with?
Mainly with Mr. Tucker.
And at
And
some
me.
and you.
Yes, I was in the room.
Okay. And at some point, you got involved in the plan to go over there.
Yes, I did.
Now, there seems to be a little confusion on the cross about how many trips over to the treehouse were made prior to the actual robbery. So let's be clear. You testified that you guys went over there and did, I guess, for lack of a better phrase, a drive-by. Is that accurate?
Yes.
And after the drive-by, were there people or cars at the treehouse at the time?
Yeah, I'm never eating at
And you
Burger
guys went
King
back to
again.
the warehouse. And when you went back to the warehouse, what was the purpose in going back to the warehouse?
For clothing.
And about how many minutes later, if you can estimate, did you guys head back over to commit the actual lick?
I feel like about 5 to 15 minutes. I'm not 100% sure of the timeline.
Okay. Now,
I can't get Burger King. We don't have a Burger King in my town. Well, Waffle House, isn't that where the fighting is?
I retrieved item number 7, it's an evidence from the court.
Yeah.
Chris, let's go into the electric one. Or let's
Yeah, I
go
don't
to
like
the other
Burger
one
Kings.
first.
They're all too filthy. Always filthy.
David, you know.
I could eat Chinese.
All right, Chris, let's go to 1943.
Oh, they actually wrote down the time code. I don't like sushi. Well, I've been to a Burger King in bigger cities. I do leave my little town sometimes. I do like a Big King XL meal.
Travis, it's coming up here, 1943 and 22 seconds. Okay, right there. Is that consistent with your truck pulling over to the treehouse?
Yes, sir.
All right. And is that consistent with what happened on the date, November 17th of 2017?
Yes, sir.
Now, on this is your initial approach. Is that accurate?
Yes, sir.
Did you guys stop or did you continue going after that initial approach?
I continued going
And again, if you can refresh the jury, why did you do that?
because there was somebody there.
All right.
Or is this is the first one? No, this was the initial drive-by.
Not the initial, right?
This is the one
Oh,
before
now he's saying something
I stopped
stupid.
and they got out.
Okay. So after leaving the warehouse, when they were dressed in black and with weapons, this is your first approach after you left the warehouse?
Yes, correct.
Now, if you look to the right of this boat, between these two boats, back in this area, we see your truck go all the way through. Is that correct?
Yes.
Now, there's some talk here. There's a glare there, right, on the front of this boat?
Yes, correct.
Do we know where that glare is coming from?
No, sir, we do not.
It's obviously not your headlights, right?
Obviously,
I mean, where's your truck at this point?
not there.
Is there a glare coming from this window?
That's a light
A light?
on. Yes, that's a street lamp at the CVS.
Okay. But the glare that we're seeing there, is it fair to say that's not coming from your truck?
Yes, this is fair to say.
Because your truck at this point is where?
Not there.
Okay, not there. Where is your truck? Tell the jury where your truck is right now.
Driving around the block.
All right, fair enough. Okay, Chris, if we go to, actually, so,
Of course, a Finnish Burger King has a sauna. According to my tax critic.
Your Honor, may I move up a little bit closer so I can see here?
Yes.
Thank you.
Travis, I'm going to again have you focus your attention to the left of that big boat in the middle of the frame.
Yes.
Do you recognize that?
Yes, sir.
What is it?
My truck.
Okay, now it's a minute and a half, 2 minutes later, right?
Correct.
Minute and a half later?
Correct.
All right, would this be consistent with you reapproaching the treehouse after the first drive-by?
Correct. Yes.
Now focus your attention over here. Keep going.
Yeah, that's the truck.
Can you tell for sure where your truck is at this point?
Yeah, I can.
100% no.
Now, there's a couple different layers going on here, right?
You can see the top of the truck over there if you move. Well, if he is late tomorrow, he'll be found guilty of that and thrown in prison. Well, at least we're doing something because this prosecutor I think he's allergic to microphones. And it doesn't help that both of them are standing in front of what we are supposed to look at. It's making it really hard to like this, both sides in this case. So go back to talking about blue crabs.
Is that you there?
Yes, sir.
All right, what's what we just saw? Go ahead, Chris. Focus over here, Travis, if you would.
Yeah, you can see the truck stopping there.
See a flash from your headlights as it approaches. Is that accurate?
Yes, sir.
But do we know where the truck is stopped at this point?
No, sir.
Kind of hard to
Yeah,
see.
it turned into a farce. You're correct.
I still see a light going on here, right?
Yes, sir.
Is that coming from your headlights?
Probably not, sir.
Now, your testimony is that this defendant and Wilson got out of your truck, right?
Correct, sir.
Does that consist of what we see there?
Yes, sir.
All right? And that's at what time now? 1945 and 47. And Chris, we take us to 1951, please.
I only think I had crab once or twice in my life. It has to be cooked with something that gives it taste. That I don't think it has that much taste, but
Travis, if you look over here,
is it crab balls or whatever is it you make them into? They're pretty good.
It's still sitting right there.
Is it, can you see this frame or not?
No, sir.
Now, we just saw
Crabs?
you top the hill. That's, we said before, that's what went, correct?
Correct.
A whole mess of crabs.
Right there. And again, who do we see running there dressed in black?
That's Mr. Tucker.
The defendant.
Yes, correct.
And
Crab cakes. Yeah, not crab balls.
No, sir, I did not.
I don't know why everything is balls in my world. KLI, we have to fill the time with something, and we can't listen to people talking away from the mic, so we went into crap mode. Maybe we should do a little crap dance and hope something happens. Soft shell crabs. No, I'm not saying crepes. I'm saying crap.
Hi, Chris, that's one, perfect. I'm going to bring your attention to some times here in a minute. Now, all right, Travis, so we've covered the videos from the night of the event. I want to go to what was going on with you after they brought you down to the station under the guise of looking for your items from your truck. Now, you got to the station that night, right?
Yes, sir.
Initially, when they switched the script on you and they started asking you questions about what happened at the Treehouse, were you surprised by that?
Yes, sir, I was.
Did it catch you off guard?
Yes, sir, it did.
And initially, during your conversation with them, did you come clean right away and give them
No, sir, I didn't.
own up to what you had done?
No, sir, I didn't.
What were you doing?
I was backpedaling. I'm scared. I was processing in my mind what avenue I wanted to take.
And so, as they asked you questions, were you being 100% truthful with their answers?
No, sir, I wasn't.
Were you trying to mislead them or diffuse them?
A little bit, yes.
Were you worried about minimizing your involvement in this crime?
Yes, sir, I was.
Again, at this point, were you familiar with the principal theory?
No, sir, I wasn't.
Were you familiar with the idea that you could be held accountable for everything that happened, even though you were in the truck that night?
No, sir, I was not.
As they questioned you, did they start to confront you with more and more evidence that they had in the case?
Yes, sir, they did.
Now, you specifically testified that Phelps put it together, right?
Yes.
She's the detective or the lead that was in there?
She was the captain, yes.
The captain, okay. And you said on, I believe it was on direct and on cross yesterday, she nailed it 100%.
Very smart detective, yes.
When she went through the events with you, were you surprised at how close she was to the truth?
Yes, sir, I was.
And as she talked to you, and we saw it in the video yesterday, did she present you with her theory of what happened?
She did.
Okay. Now, let's go, Chris, if we could, to 2019, please. It's at 2019. I'm not sure which one it's going to come up on. Maybe that one. Okay, we got to go to 20 and 9 hour 2019 minutes.
2019. I like shrimps. I really like shrimps. That's good. And deep fried octopusy.
And do you want some water?
Nothing better than fresh white bread with mayo and fresh shrimp on top of it. Octopusy. Irish. Grow up. Calamari. But I'm not Greek, so it's octopusy.
Okay, Chris, go ahead and stop.
You ladies have a dirty mind.
And pause, Chris. Now, we're at the point of the interview where you were talking more clearly with Captain Phelps. Is that fair to say?
Yes.
Are we at the point where you have
I'm not a big fish person
decided
either.
time to come clean?
Yes.
What brought you to that decision, Travis?
Actualization of the fact that somebody was dead and I was responsible, and that I wanted to make sure that this was resolved.
Now, At that point, you decided time to own up to it?
Yes, sir.
And is that what we saw in the video yesterday where you got very upset? I think you had a moment where you really got overwhelmed?
Yes.
Why
I
is
just
that?
don't like all the small bones in fish.
Actuality, reality slapping me in the face.
The reality is that you were involved in an event that turned into a homicide.
Correct.
Scary stuff, right?
Yes, sir.
Now, you're talking to Captain Phelps, and she's asking you about the
We
knife,
have
right?
pretty good
Did she
fishmonger in
tell
my
you
town
what
as
the
well.
knife looked like?
No.
Did you tell her what the knife looked
Only
like?
8 minutes.
I mean, they knew a knife was involved, right?
Yes.
The guy had
Oh,
been stabbed
thank
to
you,
death, right?
Dave.
Yes.
So when she asked you about the knife, did you describe the knife?
I did.
And how did you describe it?
I described it the way it looked, the way it is.
Red, black and red.
Black and red with a serrated edge. Yeah, black and red with a serrated edge and a smooth edge on one side and a silver pommel on the bottom.
Had you seen that knife before?
My brother's granddad used to fish a lot,
Once
and
or twice.
Where did you see it on the
he
night of
smoked
the
eels,
Treehouse
and
stabbing?
And
I
saw
just
it in the
couldn't.
house, and then I saw it in Tucker's hands.
Tucker's hands.
Yes,
You guys sit right there.
yes,
It's in his hands when he came out of the house.
yes,
Dressed in black?
yes.
duh.
You told Captain Phelps. Now, when Captain Phelps was asking you about details about the knife, did she show you the knife?
No.
All right. You told her what color was the handle.
Black and red.
All right. What about the blade? Did you tell her
Serrated.
Yes, it did.
what you say?
Serrated on one side and sharp on the other. Smooth on the other.
Serrated on one side, sharp on the other. Throughout your interview with Captain Phelps, what did she tell you she wanted from you?
The truth.
What?
The truth.
The truth, right?
Yes,
She say it more than once?
yes.
Matter of fact, at one point, doesn't she say to you, tell us what happened, and your response to her is what? You just said it,
Yes,
right?
yes.
When you said you just said it, what were you meaning when you said that?
I was meaning that she knew the truth. She had, through her theory, for lack of better words, nailed it.
And what
she
was
just
her-
said it.
Do you recall what her response was when you said you just said it?
She said she needed to hear it in my words.
She wanted to hear it in your words, right?
Yes,
You tell her what happened. And then you went and you started telling her exactly what happened. Is that fair?
yes.
At 2020, Chris? Yes, please.
Come on, Chris. Can I move on?
And I'm going to let it play for a couple of minutes because then there's a couple things within the next 2 minutes I want to talk about, okay?
I don't eat any poultry. So all of us have weird things.
Mhm.
Pause, Chris. She asked you if you knew who stabbed the guy, right?
Yes,
And she asked you if you had to guess, which one would you say?
yes.
And what was your answer?
I didn't know well enough to develop a guess. I didn't know either one of them well enough to know who had done it.
Did she give you the name of Tyrone Tucker, or did you offer the name?
I offered the name because she said that I knew who did it. And I think I offered it in the form of a question.
So you offered the name of Tyrone Tucker, not Penny Phelps.
Correct.
You're the one that brought that name into this narrative. Is that fair to say?
Yes, sir.
Not Penny Phelps.
Correct.
So when the defendant says this was her narrative that you simply endorsed, that's not accurate, is it?
No, sir, it's not.
Go ahead, Chris, play.
It annoys me we can't hear these videos.
Chris, why is
It's
the video not?
I know it's not for the audience, it's for the trial, but still, it's annoying we can't hear when it's so important. Well, sugar don't swim in the ocean.
Same as the audio, but the audio is what's important to me at this point. The jury's going to be able to look at this. It's in evidence. So let's just go with the audio. Chris,
Your
go
Honor,
ahead.
can we sidebar for a second?
Even he's getting mad. Uh,
Tomorrow it's probably going to go to 5 again tomorrow. So, and I have to be up early Saturday and bake. Or else I would I could eat some ice cream.
ooh.
I love ice cream.
What's your favorite flavor?
I like banana split flavored or anything with mint flavor. Mint and chocolate is great.
Like mint chocolate chip?
Yeah, that's great.
Oh.
You're back.
Okay.
The trial, if the audio sucks, it does matter, and it's for us to be. Well, I can't help it. Sorry, Iris. I try, but I just liked that he admonished the defendant to use the microphone, and when Tackleberry never uses his microphone, that's no, because it dissolves.
What did you call him?
Tackleberry,
Tackleberry?
Police Academy. Haven't you seen that?
Go ahead and hit play.
No.
What?
I have not.
You haven't? There's, I think, 7 or 8 Police Academy. Don't watch past number 4. Haven't you ever seen any Police Academy?
No.
Oy, 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 oy.
I haven't. I don't know why.
Just watch the first 4. Jamie's too young, I know.
Yeah.
Well, I'm 27 and I watched them.
I mean, are they really that funny? Or you guys just pull them a leg?
Didn't you like Crocodile Dundee?
I did not. One bit did I not. Like, I hated that movie.
The viewer count just dropped 8 people.
You put it up at all?
Moscow is bad. I don't like it. But I like that female instructor. Moscow is 6. Oh,
Everybody
sorry.
told me Crocodile Dundee was a good movie, and I was very upset.
It's a great movie.
Crocodile Dundee?
Oh, number 5. Number 5 is the one where they have all the foreign police officers visiting. No, they're just trying to reestablish him as a credible witness, and it's doing good. I am.
Why?
Have you watched Ghostbusters?
Yes, those are my favorite movies.
Did you watch the Ghostbusters Not to Be Mentioned?
The what?
The Ghostbusters Not to Be Mentioned.
The chick one?
Yeah,
Oh, I refuse on that one.
thank you.
That, not even close.
There's no Crocodile Dundee 3, is there?
I thought somebody said there was a lot of them too.
Excuse me.
He was 8
building up to a
minutes late.
question here, or just
Yes, Judge.
okay?
All right, Chris, go ahead and pause. I was hoping to get to the part, Travis, but let's just talk about it. One
His excuse was, I'm really bad at traffic. That's his excuse.
Point you offered to draw a map. Is that accurate?
Yes.
And what was
A
that map?
Slimer decor?
What
No,
were you
I didn't see that.
requested to draw, or what did you request to draw when
Yeah.
you wanted to draw a map?
The route.
He lights up and makes
And-
noises.
Did Captain Phelps tell you what route you took?
No.
Did you tell her what route you took?
Yes.
Matter of fact, at some point, she says something on the map and you correct her, don't you?
Yes.
She's pointing in the wrong direction and you actually corrected her as to which direction your truck was going.
Yes, sir. I believe that was
All right. At that point, is this your narrative or her narrative?
mine.
Yours, right?
Yes.
You gave a detailed description about the planning of the robbery, correct?
Yes.
Did they know about the details in the plan?
No, sir.
Where'd those details come from?
That came from me.
What about the details in Rory Wilson's mask? Is that something they provided to you?
No, sir.
Where'd that information come from?
That came from me.
What about the gaiter that this defendant was wearing? Did she provide
Objection,
you with
Your
that
Honor.
information?
I'm
No.
sorry, what's the objection?
There's been established those wearing anything.
Well, I disagree. It might be a point of contention, but it's a legally cognizable question, so I'll overrule the objection.
Let me ask it again, Travis. So the gaiter that this defendant was wearing, did Phelps give you details on that?
No, sir.
Hello,
Where'd that information
MLS
come from?
Raiders.
Came from me.
Now, describe the defendant. He looked
Hey,
different back
Wendy
then,
H.
6 years ago. Is that accurate?
Yes.
Hi, Wendy.
Tell the jury about how he looked. Do you have a bigger goatee, smaller goatee?
With a goatee about this long. Straight down.
Long.
Long.
All right. Did he have a full set of teeth?
So cute.
Sean, if you're watching when they play the videos, you can't hear anything on the videos. That's why we're just talking.
The gaiter that he pulled up, does that cover his goatee?
Yes. Yes.
He's still in shorts.
I apologize.
The knife you gave the details on, is that fair to say?
Yes.
Hello.
Now, the money that you got, you said it smelled like perfume.
Yes.
Is that something that they told you, or is that something you gave to them?
Something I gave to them.
Solomon Anderson Zachariah Anderson police interview, I believe.
The defendant brought up the
Just a little short
scenario
one.
about April Walker. Again, who was April Walker?
Rory Wilson's girlfriend.
Roy Wilson's girlfriend. Was she living at the warehouse as well?
Yes.
The defendant asked you about these threats and
I wear shorts and a
timing of
hoodie.
these threats. Do you remember on cross?
Yes.
When you left for Big Pine,
Have fun,
was
Wendy,
April
and
still in that
Wendy.
warehouse?
Yes.
have fun with the
And you said
Kings.
to the defendant when he asked
I
you,
guess
you
it's a
didn't appear to be
sports team.
nervous or scared, right?
No, sir.
Sacramento
that's what
Kings
you testified to
basketball.
on cross.
Okay.
Yes.
Now, you were up in Big Pine for at least a day, then they brought
Have
you
a
down to
little
the
shoot
station,
around.
right?
Yes.
In that tape, when we see Captain Phelps come into the room and tell you that April Walker's nervous and scared, is that before or after you left the warehouse that morning?
After.
After, right?
Correct.
So when you left the warehouse, had April Walker received those threats?
Not as far as I know now.
When Captain Phelps came in the room, what did she say?
She said that April had received threats.
Had just received threats.
This is called crack addict. No, he's not on crack. He's on meth. He has a mohawk ponytail, pony mullet. It's not a rat tail. That's down here, but it's a pony mullet. We like that. You like it. We know you like that. Hey, MG.
AMG.
Defendant also asked you about whether you saw blood on him or on Wilson that night, right?
Correct.
What color clothing were they wearing?
Ponyhawk is a good one too.
Is it easy to see
Oh,
blood on
Ponyhawk.
dark black clothing?
No, sir. It's not.
Were you looking for blood on them that night?
No, sir. I wasn't.
Had you suspected that somebody had been stabbed to death inside the treehouse?
No, sir. I hadn't.
So when you walked with Wilson back from that CVS, I'm sorry, I apologize. When you walked with Wilson back from Tom Thumb, were you looking at his body to see if there was blood on it?
No, sir.
When you and this defendant were in the warehouse right afterwards, and this defendant was mad at you for having left him, were you looking at his body for blood?
No, sir. I was not.
Again, what color
Yeah,
clothing was this
they're
defendant wearing?
down here, right?
After you left,
Hey, Brian.
after you left that place in Big Pine, you said your truck was empty when you left, right?
Correct.
And you unpacked the stuff into the house, right?
Correct.
And for all of you MLS readers, if you're not familiar with this case, this is a pro se defendant who was offered a plea deal, 2 years already served in prison on a murder charge. He could get off with 2 years already served. And he said, nope, I want to go to trial. And he has been absolutely bad. He's been late 4 days in a row for court. And the judge just told, because he's out on bond, told him, if you do it again tomorrow, we will arrest you so we know where you are. So this witness on the stand today is the only one who can place him at the scene of the crime, because 208 pieces of evidence were thrown out because of shoddy police work. He spent 4 hours yesterday talking about absolutely nothing to do with the trial, just watching tapes we couldn't hear.
Then the police came and looked at your truck, right?
Correct.
And then they invited you to come down to the station and look at this other stuff they had, right?
Correct.
Did you ever see your truck again after that morning or that day?
No, sir.
So when you left Big Pine, you never saw that truck again?
No, sir, I didn't.
When you left Big Pine, was the truck empty?
Absolutely empty.
So how did you find out that somebody had taken all your stuff out of the house and put it back in the truck?
When I received the search warrant affidavit.
Were you surprised to find that all that stuff was in your truck, or did you figure that's what was going to happen with your stuff?
I figured it was, I really didn't know, but yes, I was surprised to know that it all had been piled into the bed of my truck.
Now, you are a knife collector, right?
I am.
You had a pretty extensive set of knives. Is that fair to say?
Yes, sir.
And were those knives back in that truck again after they cleaned out the house that you were staying at?
Yes.
Or that you were going to stay at, right?
Yes. Yes, the knives were in my possession when I went to that house, correct?
Okay. Now, when you finally decided to own up to your involvement, that's when you, I guess, came clean with the detectives, right?
Yes, sir.
Did you do that before or after they showed you the videos from the electric company and from the Cosme Marina?
Before.
So those videos that this jury has seen, you were not shown those until after you gave them your statement. Is that accurate?
Correct.
Go have fun, Fedorowski. Dress warm.
In 6 years, can you still in your memory clearly see this defendant running from the the treehouse that day?
I can.
And that part I don't feel like
Defendant
he's...
asked you today, you wanted to get out of there quick, right? You were scared, you wanted nothing to do with this, right?
Correct.
But you still wanted to get high, right?
Of course, that's the insanity of addiction.
So you weren't about to leave until all the drugs had been smoked at the very least, right?
Correct.
Of course.
Let's talk about these deals. You came in and you gave statements, right?
Yes.
And we just went through the one that you gave to the detectives back in 2017.
Brian, as soon as I see a live link go up, I'll jump over to Karen's case, because this is kind of, it's been circling the drain for the last day and a half. Nothing really happens. So I'm gonna jump over if they go live with the Karen case. I have another screen ready to see if they, and then we'll jump right over. But it's not till 3 o'clock, so there's some time to go yet. Well, as long as you're not objected to and the judge doesn't call it leading, you're not leading. Stace, totally agree. Everything for you, Brian. You know that. Yeah. But again, at least this guy owns up to him being an idiot. The other one just believes he's the smartest person in the room.
Yeah.
Is that fair to say?
Correct.
We played that pretty much in its entirety yesterday, right?
Correct.
Now, In April of 2022, you were approached again about potentially potentially entering into cooperation with the state.
Correct.
And before we talked about any deal, did you in fact give another sworn statement?
I did.
And that was prior to any deal being made. Is that accurate?
Correct.
Judge, at this time, the state is going to move into evidence what has been marked as P as in Papa.
Objection.
Yes.
Today it wasn't that long. It was just about, because we started late, so I would say roughly 45 minutes, and nothing else than we talked about yesterday came out. Nothing. I think this is the fourth sidebar of the day.
Or let the state set the stage for whatever they're doing, and then
P as in pro se, yeah.
P as in Papa.
do we have an exhibit that's marked?
Yes, Judge.
What
It's
is
marked
the-
O as in Oscar,
Okay, what are you doing with it?
seeking to move it into evidence.
Okay, is there an objection?
Yes.
What are you doing with it? He's
Now
so
we'll
funny.
approach the bench.
And if any of you new people have any questions, please ask. This is a pro se litigant in a murder case out of Florida. He was offered a 2-year deal to plead guilty on a murder trial, in a murder trial. He said, nope, I won't take that deal. So his lawyer said, we can't represent you. I'll do it myself. We are believing this guy will talk himself into a jail cell because 4 days in a row, he's been late for court. He can't ask a question without getting everything wrong. And he is arrogant as all hell. It's in Florida. Key West. You can Key Lime, Key West.
Key Lime, Key West.
It's because let me set the scene for you. They had a police officer doing most of the investigation. She is now a 911 operator because she wasn't fired, but she was reprimanded because she had late filings, didn't do the paperwork in 17 out of her 19 cases. That's one of them. And because of the shoddy police work, there was an internal investigation into the police operation. 208 pieces of evidence were thrown out. So they said, okay, just take the 2 years, which he already served. He already served the 2 years. So he would be free to walk. The only thing, he would have a felony on his jacket. And yeah, you can't vote and you can't buy a gun. That would be all he had to do, is just say, yeah, I did it. Bye-bye. No, he has a lawsuit against the state because of that bad police investigation. So he thought, this is a home run. But he's such an idiot. He was supposed to impeach the witness we have on today and really make sure everyone knew he couldn't tell it was him. And even though this guy is a meth head, he seems a little rehearsed sometimes, but he's more trustworthy than the defendant. And he's been late 4 days in a row. The only thing talking in his defense right now is that Paula, one of the persons who were attacked at what's called the Treehouse, where they stole money and drugs from them, she says it wasn't him. But the guy who's supposedly the getaway driver is the one on the stand today, and he said, yes, it was him. So it's it's the lady who had the bad fashion sense. She also had a really, really bad case sense. No, don't say that, Kayla. That's not nice. That's yeah. Do you think he did the actually ending, or do they think they think that Detroit, who they already convicted, did the unaliving? This guy was just present, but still he's accomplice. An accomplice to murder. It could possibly be life in prison he gets, and he could have walked with 2 years already served and not been able to own a gun or vote, I had taken that deal every day. Yeah, he would have been out of prison. He was already out. He was out on bond because his high school sweetheart was the co-founder of CrossFit. She paid the $2 million bond on him. So he's out of prison. He's been out of prison for, I believe, 5 years now. And still, Friday, he turned up 45 minutes late for trial. The judge yelled at him. Yesterday, he was 20 minutes late for trial. The judge yelled at him. Today, he was 8 minutes late because he's not a good guy with traffic. So he tried to be early. So the judge told him, if it happens again, I'm putting you in jail so we know where you are. Yeah. Well, thank you, Rachel K. But always, if you're here and you just jump in, please ask the questions. I'll gladly stop and talk about it. Yeah, she paid a $2 million bail. Well, he had lawyers, but when he didn't take the plea agreement, they said, we can't represent you. She's evil, trust me. It would be for the best. Oh, I was thinking the co-founder of CrossFit. Well, CrossFit is evil, so yeah.
CrossFit is evil.
Hey, Brian, talk nice about your president's son. Yes, it was supposedly it was his wife. Jamie, do you ever had email sent to you by Paulina Poiler _ hey, how are you in you? What country do you live in at the moment? In at the moment. How many years old are you? I again _ what I alone. One serious attitude search. I hope that you would like our communication continue. Await your answer. Polya.
So first of all, I don't know what O is. I mean, you asked the witness if he remembers.
Answer her.
I think it was 2022 making another statement.
Better return her email.
Yes, sir. So, Judge, I'll let me explain. In April of 22, when we approached the defendant about potentially doing a deal with him, we said before we
She sounds legit.
we want a sworn statement, and he gave us a sworn statement. Normally, that statement would not be admissible. It would be hearsay. However, under Rule 90.801.
No, wait a minute. So O is some.
O is that proffer that he gave, an audio of the proffer or the sworn statement that he gave.
Yeah, Sal can save her.
My office.
So
Hey, Master,
you're
yeah.
into evidence on Europe. Mr. Tucker's objecting. So let's hear what the state's basis of admissibility is.
90.801.
Yeah, are you sure it isn't David?
Subsection 2, subsection B. A statement is not hearsay.
I got
The
myself.
declarant, Mr. Travis, testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement is
Page.
consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. This defendant has been attacking this witness now for a day and a half about you'd do anything to get out, wouldn't you? You'd say anything. You even said in the video, I'll do anything you want. He has made allegations of a fabrication on this defendant in order to get a deal. He's made allegations of improper influence of Penny Phelps. And He's made allegations of the motive to do it, meaning this defendant did not want to go to prison for life. So basically, he's here saying anything he has to say in order to avoid that. That's specifically what this rule is meant to address. So normally, a prior consistent statement would not be admissible, but now that that has been established, it is my position that statement should be admissible as a prior consistent statement
Sorry,
offered
I'm just
to,
getting a phone call. I'll be back.
Okay.
I guess, to rebut allegations of improper influence, motive, or recent fabrication.
And the defense's position is?
Defense's position is that, again, as far as his motives, as far as the deal he cut, yeah, that one is self-explanatory. I didn't have to point that out. As far as Ms. Phelps, is she going to be addressed in that statement? The statement that you're trying to enter into evidence on cross? I mean, not a cross, I'm sorry, on redirect. You're trying to introduce new evidence into redirect, and does that actually establish, does it say anything about Penny Phelps?
I don't know.
Because I mean, that's what he's using to establish this law here. He's trying to say that, because he questioned Mrs. Phelps's motives, that would establish this law.
It's not a question of Phelps's motives. It's a question of this defendant, or this witness's motives. He has been alleged to have fabricated this story in order to get a deal. He is alleged to have been improperly influenced in order to provide this story. This is specifically what this rule is designed for. It is specifically designed for a witness such as this who has been attacked by his motive for testifying, the content of his testimony being improperly influenced, and that it was fabricated to get a deal.
But does it allow you to enter new evidence on redirect?
Well,
Judge, I'm not teaching law to the defendant, so.
We're having a legal argument. This is exactly what when this whole business about the defendant wanting to play the interview, interrogation, whatever you want to call it, of Johnson with Penny Phelps, this is what I don't want to say warned about, but acknowledged that the door may be opened.
Yes, sir, that is correct.
Excuse me?
I said I understand, Your Honor.
Okay, so now the question is this within that rule? So what's the rule?
Judge, it's 90.801, parentheses 2, subsection B.
What subsection?
I'm sorry, Judge, subsection 2B.
We can speed it up because we're behind. Oh, this goes on forever. And for those who haven't been following this trial, the last 3 days has been like this. Hours of sidebars, hours of nothing happening.
Okay.
The state was
David is
supposed
not here
today at
The declarant
lunch.
testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement is subsection B, consistent with the declarant's testimony. It is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. I
Yes.
don't think this is recent fabrication because recent fabrication would mean that somehow or other he's being alleged to have in the very close
Aaron,
to his
you missed
testimony
15 minutes of
fabricated, and
sidebar.
then the advocate for that witness says, no, here's something that he said months ago that shows that this isn't recent fabrication. So it seems to me it's improper influence, that the Penny Phelps interview was played by the defendant to say that Penny Phelps fed you this narrative, to use the term that's been
Eris,
employed here.
remember,
And
New
you
Year.
basically said, yeah, that's it. And it
New
was
year,
her
new
idea,
you.
not his idea. So,
Oh, we are cool 100 people watching. Please do the YouTube thing. Oh, when it dropped down to 99, it's a Senate.
the time was.
Don't do the YouTube
Phelps'
thing.
interview was in, when did we say?
2017, Judge.
The testimony here is in 2024, and the
Well, just because the defendant is an idiot, our chat isn't.
is in 2022. So could you just explain the argument again, Mr. Mansfield?
Right, Judge. So
I
now
shouldn't be
that, now
grifting.
that he
It
has
cost us
attacked the
viewers.
veracity of his statement as having been coerced by Penny Phelps, well, he gave another statement almost 5 years later, and it's consistent with the testimony he gave this jury on direct examination. So again, if it was the Penny Phelps story, well, 5 years later, he gave a consistent version of those facts, identical to what he testified to this jury today. I'm sorry, during this trial.
Okay, and so anything further from the
Well,
defense?
I know I'm kind of an idiot, so.
Consistencies between the interview he gave with Penny Phelps and what he's given today.
Well, I haven't hired you yet, so can't fire you. That's the problem.
Not the inconsistencies. I believe the whole implication that the defense is trying to say is it's basically the whole thing is a lie. That it's Penny Phelps' version of events that Johnson has just adopted as his own in so many words, and he's fine-tuned it a bit.
Yes.
But
Your Honor,
yes,
if
sir.
I may, the statements that he made, again, Penny Phelps' time, yes, we do believe that they were fed to him. However, he's had 6 years now to fine tune those statements.
Right.
So, again, even all the, yes, he was there. He can draw a map. Yes, he's there. He could do all that. He could do everything that the state's saying. That's true because he was there. That's very simple. And yes, because he was there, he can give all that information and probably keep it accurate. The part that's problem is that Penny Phelps gives him the one key that he needed to get that deal. I'm the getaway driver.
Judge, he keeps arguing the very nature of why he keeps arguing that Penny Phelps unduly influenced this defendant. And the rule allows for me to play a prior consistent statement that corroborates his version because the defendant has attacked it as being unduly influenced.
Your Honor, if I may, one other thing.
Yes, sir.
Okay, this prior and consistent statement, I mean, that would make sense if he had actually given that consistent statement prior to Penny Phelps. I'm sorry, consistent statement prior to Penny Phelps. Then it would make sense.
What? I'm not sure what he's arguing. He wants to say that Penny Phelps
Yes.
made him
With abundance
say
of
he was the
caution,
getaway driver.
Because I don't want to create an appellate issue, I'm not going to move it in. I'm not going to seek to move it in.
I think that's a wise choice. Because one way or the other, it's a close call. I mean, one way or the other, it's a close call.
I truly believe this is the kind of trial that you get one shot at, so I don't want to create that issue.
That's pretty smart.
May I ask, do you have a witness standing by?
Yes, sir, we do. Two of them.
Well, I don't think that's going to happen, Mr. Tucker. You've had more than ample opportunity to cross-examine to everything multiple times, so we're not going to be having any.
He wanted to say that it was Penny Phelps, the lady in the amazing outfit, who told this guy, "You were the getaway driver, right?" And he changed his testimony after that. But he couldn't really make him say it yesterday. And they wanted to put in his previous his amended statements, but then they said, no, we won't do it because it's going to be an appeal issue and we don't want to do that. So they pulled it back and then it went away. And then he wanted to recross him and he's told, no, you can't do that. This is live, Nick. And hey, how you doing?
Hi, Nick.
Yeah, but he spent like 6 hours talking about absolutely nothing.
Recross, sir. That's not the norm to begin with. I made an exception, but anyway, I won't repeat myself.
So
I won't pee myself.
Follow-up and I'm done.
That's what I thought he said.
I don't know what time.
All right, bring in the jury, please.
He said I won't.
So now we're gonna have the DNA expert.
I'm sorry?
Was it the Emmy or the
Whoever's sitting out there. One of the two.
one of the two?
Okay, the
One of
clerk
those.
is concerned if there's some exhibit that's in the machine that she doesn't have. She's very mindful of keeping track.
Why
of
are you on your phone in court?
definitely, desirable. Thank you for your patience. We've handled our business and back to the redirect of the defendant.
Thank you,
The
Judge.
witness, excuse me.
Nick, it's a pro se litigant. He's been late 4 days in a row for trial, and he's been spending 6 hours to try to say this witness wasn't the getaway driver, but one of the guys who did the unaliving, because this is the only guy pointing the finger at him. And he spent 6 hours talking about stuff that happened 4 years before the incident, and he thinks he's the smartest guy in the room, and he's almost as stupid as I am. Hey, Indigo, how are you doing?
I'm sorry, sir. So picking back up, Mr. Johnson. So just to confirm, when you were approached in April of 22 about working with the state, you gave another sworn statement,
Correct.
and then you testified to the jury today.
Correct.
Were you consistent with that statement?
Yes.
Just 1 second, Judge. Judge, at this time, I have no further questions for this witness. Thank you, sir.
1 second. We're going to need to approach the bench here.
Oh, and they have sidebars all the time. This is the 5th sidebar today, and they started at 1 o'clock. So it's they were supposed to finish today the state.
You maintain some contact with the state to get further details.
Understood, Judge.
Any other instructions anybody wants at this point?
No, sir. I just would, since he's still under potential recall, no talking about the case to anybody outside the courtroom.
Okay, take care. If you please step forward through the gate, approach the deputy who's positioned right in front of the witness stand.
What? How?
You stop
What?
right there, turn, face this lady, raise your right hand.
Do you solemnly swear or affirm that the testimony you will
Is that a
give
garden gnome?
shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, thank you. Have a seat on the witness stand, please.
What the?
Good afternoon, sir.
Judge, may I proceed?
Yes.
Dr. Stegmaier, you all set up? Okay.
I am.
All right, good. Good afternoon, sir.
Good afternoon.
Dr. Stegmaier, could you state your name for the jury?
Absolutely. I am Dr. Michael Robert Steckbauer.
And how are you employed?
I am the current District 16 medical examiner.
Oh, so this is the medical examiner.
Okay, good. Dr. Stegmaier, you are employed as our medical examiner?
I am.
What are you talking about, lawn gnomes?
Down here in Monroe County.
About 6.5 years.
Okay?
He looks like
this
a
is the
lawn
part where I ask you to
gnome when
take
he
the jury
walked
back
in.
A little bit about the progression of your career to get you to where you're at today.
Yes.
Yes, sir.
So,
I'm just gonna
that
skip
long
ahead
odyssey
till live
started,
because this
many
is
years
just
back.
his. I went to school.
Now, are you a member of any specific groups or specialized groups?
Yeah, most pathologists,
Tintin hairdo,
specifically
yeah.
forensic pathologists in the United States will be members of the
Yeah.
National Association of Medical Examiners. It's really our only major group. We do have another group, but they're very minor compared to.
Yeah, they have a very
names.
inclusive
Almost all
police
forensic
department. So
pathologists in the
hobbits
state are
work
members of NAME.
at the police
And then I
department in.
am a fellow
West.
of the American Society of Clinical Pathology as well.
Have you ever been published?
I have.
And when I say published, what are we talking about?
Most of the time when you're talking about published, you're talking about either case reviews or full clinical research.
Do we really
And you
have
have been
to?
published
You just-
before?
Yes, absolutely.
Do you receive continuing education in your field, or is it you've already known it, so that's it?
No, there are no current.
But he's not the
residencies,
supposed knifer.
under the guidance of the American
there are
College of
two
Graduate
people
Medical
there.
Education that can't
Detroit
not
and Tucker are the two people the state says was there, and
So
Detroit
I
has
do
been
do continuing
convicted
medical
of
education. I do
the
that both
unaliving.
for my board certification as well as for my medical licensure. The state licensure board here in Florida.
Yeah, don't
requires
diss Rim.
30 to 40 credits of CME per year. Some certain classes mandated, others you can do it in whatever area of medicine you'd like. And then the American Board of Pathology requires 70 credits themselves.
And do you have to do that to maintain your accreditation or your certificate to practice?
My certification.
Certification.
Now, there is, I guess, one other caveat to that. I was unluckily one of the last people in my year group period that still had to take a high stakes test at 10 years to renew my board certification. Thankfully, they got rid of that and they changed it in pattern, but I did actually about a year, and I think that was a year and a half ago, I took a large exam, 10-year exam within my field to show, in fact, that I did still know what I knew and that I had kept up on it.
Now, are you board certified by the American Board of Pathology?
Yes, that is correct.
Is that above and beyond your regular certification, or is that the one we're talking about?
That is the one we're talking about.
All right, fair enough. Now, let's talk, you already explained to the jury an autopsy. You said an autopsy can determine cause and manner of death. Is that right?
Yes, that is correct.
So let's talk about the difference. When you say cause of death, what are you referring to?
The cause of death is that thing that led to the physiologic derangement in the body that was no longer compatible with life. The manner of death is a category that the cause of death fall within. I like to use the example of things like a firearm death. You can have a firearm death that is in.
It's hopefully going live in an hour and 15 minutes. It's not until 3, but I hope it'll be on the. Normally it'll be on
An hour? No, 3 is in like 10 minutes.
Oh, in 3. Oh, sorry. Yeah. I have to do math. Yeah, I am an hour. Normally it'll be on WCVB, but I'll jump over there if it goes live.
Yeah. Hi, Michelle. Haven't seen you in a while. How are you?
Yeah. Hey, 15 minutes. Thank you. The topic, well, it's just a pre-title. Today, I think they'll be talking about some motions to what is it? I think there's two motions from each side. One to suppress and another one to not suppress, and it'll 3 is in 10 minutes. Thank you. I'm good. Battling a cold and waiting for this hearing. Yeah, let's hope it goes live, because I know there's a Zoom meeting, but that will be flooded because they leaked the number to Facebook.
Back.
Yeah.
Homicidal.
I hope you feel better.
Somebody pulled the trigger.
Oh, Court TV will be there. Yeah, they'll probably put it on their website.
Suicidal.
Oh, yeah.
Somebody pulled the trigger themselves. You can have a firearm death, although they're not common. You can have a firearm death that is going to be accidental. The firing pin or something is malfunctioning, and the
no, it's actually on the website,
and the projectile strikes somebody. In that case,
so we'll
during the autopsy, you do something called an external examination and an internal examination.
I have it running on the other side.
Correct. Let's talk about the differences. First, external examination. What, if anything, are you looking for when you conduct that?
An external examination is exactly what it sounds like. It examines the external surface of the body. Now, I do tell everyone, especially when I have police from the Academy for the Initial Training.
My friend I sent gifts to for 5 hours is in chat.
Whether that's a scene investigation that I directly perform or a scene investigation that the law enforcement officers have performed.
Remember the guy who called you fat and me and autistic?
Person who died.
Yeah.
He's in chat.
You're kind of well, hi. How are you?
On court.
That could be drug overdose, could be suicidal, homicidal.
On court
and
TV.
That investigation that they're performing is helping you to kind of move along the pathway, what may have caused it, and what sort of ancillary testing you're going to do. So then we get the body into the morgue. We do the intake, which is weighing the body, doing some photographs, and we examine the outside of the body. the general hair, state of the hair, color of the hair, length of the hair. If there's any findings in any of these things, the eyes, the general color of the eyes, if there's any findings in the eyes that would help to indicate to you what the cause of death was. Is there some yellowing? They could have hepatitis, things like this. The mouth, are there any findings in the mouth? 30-year-old who comes to you and has no other findings, and the teeth are in very bad repair, you're immediately going to be concerned about things like methamphetamine addiction. So the teeth can actually steer you in certain directions as well. You can find little linear lacerations that indicate a person was punched in the lips pressed against the teeth. You're then going to look at the outside of the body, any marks, scars, identifying features, any tattoos.
Thank you, Stoop.
Any injuries. Look at the genitalia. Are they normal? Are there any findings in the genitalia?
Why are we talking
That roughly covers
genitalia?
the external
Yeah,
exam.
why?
Once you've finished the external exam and you've taken photography and documented it, you're going to move on to the internal examination of the body. Internal examination is exactly what it sounds like. You are going to open up the thoracic cavity and the abdomen via what is called a Y incision. The tissues will be reflected back. We document all of this in place. If photographs need to be taken, we do take them of any pertinent findings. We examine the organs in situ, inside the body as they present themselves, and then we remove them. We weigh them and we dissect them further. We take toxicology specimens as we go. If available, we try to get vitreous fluid from the eyes. We try to get peripheral blood, meaning blood that is away from the heart. Towards
Sport
the common
TV has it
iliac,
on
vessels.
YouTube.
We
Yeah,
Just
but it's not
FYI.
live yet.
available. We gather
Well, they're-
bile from the gallbladder because certain substances.
And I have it running.
In bile.
Okay.
Once we've done all of that, we then reflect the scalp, open the calvarium, of course, examine the brain in place, take it out, weigh it, dissect it as well. We do keep small sections of representative sections of all of these organs and any specific pertinent findings as we go. And again, like I said, we take photographs as we move along this process if they are needed.
Now, Dr. Stegbar, let's take you back to November of 2017. Were you conducting autopsies in Monroe County at that time?
I was.
All right. And were you asked to perform an autopsy on someone who came identified to you as Matthew Bonnet?
I was and I did.
All right. And did you go to the scene on this particular death?
No, I did not.
Okay, sometimes you do go to the scene, right?
Absolutely.
All right, this one you didn't.
No, generally, if the body has been transported from the scene, of course, I'm a forensic pathologist, not a crime scene investigator. My expertise is in that body. And so generally, if the body has been transported to the hospital or otherwise, we do not attend the scene. And that was the case in this situation.
Okay. Now, the identification of the body was Matthew Bonnet. Is that right?
That is correct.
And you were asked to conduct an autopsy on Mr. Bonnet?
I was.
And do you recall when you conducted that autopsy?
Yes, the autopsy was conducted on the 21st of November at 10 a.m.
Is that at your office here in Monroe County?
Yes.
And were you alone or were you with someone when you conducted the autopsy?
Generally speaking, we almost always have a technician, and I would have had a technician on this case. I do believe at the time of this autopsy.
Don't look at it before
Dr.
you're allowed
Fasano
to.
was present. There were a number of law enforcement officers who were present as well.
And
Can we move along here?
No, it's very important not to move anywhere.
so you were asked to do the autopsy.
The testicles, the testes were palpable. I do believe at the time of this autopsy.
Why are we talking about his
Dr.
testes?
Fasano was present. There were a number of law enforcement officers who were present as well.
And okay, so you were asked to do the autopsy and you performed it, you said on the 21st, right?
And
That
why
is
do we
correct.
still have that video
Okay, so
up?
let's take the jury through the autopsy. First of all, can you describe Mr. Bonnet in general?
Get it together.
Absolutely. As per the report, the body is that of a 69-inch, 173-pound adult white male who appears consistent with the reported age of 59 years. The body was well preserved. It was cold. Rigor mortis was present. Livor mortis was present. It was posterior red, purple, and fixed. His hair was of medium length and white in color. The eyes were brown. The surrounding sclera were not icteric. Conjunctiva were not congested and did not have any petechiae. His nasal bridge was midline. The oral mucosa and frenula were intact, means he didn't have any defects within the mouth. The teeth are natural and in relatively good condition. And the external canals were free of blood.
Good for him.
His neck was generally straight. His chest and back were
A
symmetric.
good straight
outside of
neck.
the
What are we
injuries and
talking
medical
about?
intervention that were present. His abdomen was flat. His external genitalia
some
were
flat
those
abs.
of a normal circumcised adult male.
Oh, he's
They're circumcised.
The
Cool.
testes
Cool,
were
cool, cool.
palpable in the scrotum.
Oh, his testes
His
again.
external anus was unremarkable. His
God.
arms and legs were normally developed. He did, in fact, arrive to my
External
office with bags covering the hands.
rectum.
That is normal to do in cases in which it is believed that an altercation has occurred. It allows us to better process the hands.
Yeah, it's the first time we've been going into those
fingernail
details.
clippings because DNA can
I know.
be
No,
present underneath the
Karen Reed
fingernails
didn't have
from
normal
the
testes for a
purpose
59-year-old
that they
man.
may have gotten in an altercation. And so bags were present on his hands. They were removed.
Not
by
sure
him,
I will make
and I
this.
did, in fact,
A
obtain
straight neck, a
fingernail
flat
clippings
abs, some
from
good testes.
Mr.
I mean,
Bonner. There was a scar, a 3-inch hypopigmented linear scar in the lower midline of his abdomen. He did also have what we call our senile ecchymoses that had minor superficial skin lacerations. These are kind of what people call old age bruises.
oh, liver spots.
No, a lady got her throat slashed.
Yes,
But she
absolutely.
survived.
Yeah, he had a normal testy for a
The
circumcised
evidence
male.
of injury section on the report. Initially, the first thing that we described was a stab wound of his left upper arm. And the report has some specific measurements, and it has measurements of the actual wound. It has some measurements that kind of orient it on the body and how whether or not it has 2 sharp edges or just one. In this case, it had a single sharp edge at 9 o'clock. This helps us. It helps to indicate whether or not we have a single-edged weapon or potentially a weapon that has a serrated edge.
I'm 12
on
years
the
old, I
opposing
swear.
side.
So.
And then it was described as having only gone down into the muscle and soft tissue about 2 inches. He also had another stab wound of his left upper arm. That is correct. Left upper arm.
Left.
Yes.
Any
Specifically,
cut wounds
that
to the
wound
testes?
is 11.5 inches from the top of the head and 8 inches left of the midline. And so it is in the lateral aspect of that arm.
And would that wound have been fatal?
No, it would not.
And from the, I guess from the cut that was made of the body, I guess from inflicting that wound, can you give us any information on the knife that potentially was used based on that wound?
Well, again, as I stated a moment ago, it had a sharp edge that was at the 9 o'clock margin of the wound. And so that is indicative of a weapon that is not double-edged. Now, it doesn't mean that the weapon can't have a side that is serrated, but it does indicate that it is unlikely that it is a double-edged knife.
And that's for, as far as that one, correct?
That is correct.
And the lawyer doesn't like a microphone.
Absolutely. There was
No.
another stab wound within the left upper arm. It is also to the relative lateral, the outside aspect of the arm. It was T-shaped. It's a 4.3 by
T-shaped.
1.5 centimeter stab wound. It was 14 inches from the top of the head and 11.5 inches left of the midline. That stab wound went down about 3 3/4 inches into the muscle and soft tissue of the left upper arm. So that's a decent distance. You think about that, 3 3/4 inches is right about there.
And again, that's in the upper left arm. Here's the other wound?
Near, yes.
Okay, and that was in the arm. That would have been fatal.
No.
One-
The next wound is a stab wound of the mid-back. This wound specifically is a 3.2 by 0.5 centimeter stab wound. It is 18.5 inches from the top of the head and 1 inch left of the midline. And again, it is in the left side of the mid-back. It's oriented from 9 o'clock to 3 o'clock and reapproximates to 3.3 centimeters. These are just things we use when we describe the wounds. The path of the wound extends down into the posterior aspect, the back of the left side of the chest at the 10th and 11th ribs. It then goes into the thoracic cavity and it goes through the left side of the diaphragm. It does not injure any other major structures. There is a liter of liquid and clotted blood that's collected within the abdominal cavity that is associated with that wound. That wound specifically has a directionality that is from left to right, front to back, and downwards.
Yes, they have a serrated knife, diver's knife.
That is correct.
All right, and would that wound have been potentially fatal?
It could have been fatal if, in fact, no care was rendered. It did not injure any large major structures, but by going into the back and going through the diaphragm, it absolutely would have caused a pneumothorax, and no medical attention would have meant that he would have passed away.
Now, was there another wound in the back as well?
Absolutely. There are 2 combined wounds in the mid-back, and they are described exactly as that, 2 stab wounds in the mid-back that form a general L shape. And the first is given some description, same as these other wounds that we talked about, the measurements of it, 3.5 by 0.6 centimeter stab wound that is 14.5 inches from the top of the head and 2 1/4 inches left of midline. In the left side of mid-back, it's oriented from 7 o'clock to 1 o'clock and reapproximates to 3.7 centimeters. The second wound that connects with this, making that L shape, is 2.8 by 0.5 centimeters. It's 15 inches from the top of the head and 2.5 inches left of the midline in the mid-back. It's oriented from 9 o'clock to 3:30 and reapproximates to 2.8 centimeters. So then
He's getting his coffee.
what I
Look at
did
him.
with this, because these
Yeah.
wounds do what we call commingle, they combine. I described it as such. I said, please note that due to commingling of the wound tracks,
Come on,
these 2
Karen Reed.
wounds,
Let's go.
they are described together. The path of the wound extends down. It enters the posterior aspect, the back of the left side of the thoracic cavity, the chest, at the 7th and 8th
Technical
intercostal
issues.
space. The wound tract, the injuries, injures the descending aorta at the level of the 9th thoracic vertebra, and the left lower lung lobe is also perforated. Associated with that wound is a liter of liquid and clotted blood in the left side of the thoracic cavity. And the path of that wound is from back to front, left to right, and downwards.
Now, you did say you photographed for the autopsy, is that correct?
I did.
All right. But have you already shown defense counsel marked as correct composite 4 photos in it that approach witness?
Yes.
Let's talk about kind of take a look at those 4 photos and tell me if you recognize them.
So far, yes. Let me look at the rest.
Why are you
Yes, I do recognize them.
I'll just show what's on court TV right
I
now.
know. I just saw that too. Like, why are they showing him Biden?
What flavor did you order? I got what we call home black and white.
Any objection?
Oh,
M&M milkshake.
Exhibit Q for
an
identification.
M&M milkshake?
Entered into evidence
That's
is number
stupid.
16. That's a composite
Jesus.
exhibit, A through D.
I know. We need We need an MLS boring.
Yep. I'm running through all of it. So you can just enjoy this guy.
This is a photo that law enforcement frequently sends us. We ask for something for an identifying image of the decedent when they first call us. If they have a driver's license, they send us a driver's license. If not, they will send us a copy of their screen, the computer screen.
Oh boy.
As it pertains to any of these materials, pursuant to the statute, pursuant to the case law's interpretation of that statute, as it pertains to any item or matter pending or pertaining to a grand jury. So the Commonwealth felt that it was appropriate, given the subject matter, and as it would with anything pertaining to any grand jury, particularly what is purported to be an active grand jury presentation. The Commonwealth felt that the protective order impoundment was appropriate. Pursuant to the case law, I would ask that the motion be allowed.
All right, and just so we're clear, because you referenced it, I did receive, as you're all aware, correspondence from the U.S. Attorney's Office in Boston. We appreciate the opportunity to be heard, having reviewed all of the materials referenced above. The Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion. So with that, I'll hear from you now, Mr. Yannetti.
I appreciate that. Thank you, Your Honor. May it please the court. Your Honor, the Commonwealth seeks to suppress from public disclosure the contents of the 6 letters that were produced for the defense on December 4th of 2023, as well as the additional 2 letters that were produced on January 4th of 2024, which was the day before our last court appearance. I would suggest that it's ironic, however, that in order for this court to determine whether the drastic remedy of keeping those letters hidden from the public is warranted, the court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order,
just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into 2 parts.
Hey, McKinley.
First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case.
All right, so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are.
Right. So I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Why does she never have anything she needs?
Yeah.
Yeah.
Your opposition, and I don't have from anyone. So how about the second part of your argument, Mr. Yannetti?
Well, it does touch on that, Judge. You know, the Commonwealth has revealed some of the contents of some of the letters, but I
and she's
point out what they haven't revealed. You know, and just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Well, some judges just has a shitty way.
Just going to, in general terms, just give me a couple of minutes now to just look through them, Mr. Yannetti.
That's fine, Your Honor.
No, she does this
Well,
all the time. She always never had. I didn't have that, or no one provided that to me. I haven't read that yet.
yeah, I don't know if it's the state or the defense's obligation to deliver it to them to her, but she knew it was the motion hearing today was about suppressing these 6 letters, so she should. Why didn't she ask for him? That's my thing. Yeah. I think there's 4 things on the docket today. That's to suppress the letters and not to suppress the letters. And I can't remember the last 2. These are the letters pertaining to the federal investigation into the police department. It's been the big talk is, will the feds save Karen, because they're investigating the Canton. I believe it's the Canton Police Department. They probably won't. It's probably not directly linked to the Karen Reed case, because it was, as far as I know, started before this case started running into all this trouble. But the DA has written 3 letters and have three responses, as I believe it is, and those the defense wanted to bring out in the open, and the state don't want it out in the open. But the feds have said it's fine with us. Yeah, if the state doesn't do it by the defense, because we know in this case the state is really, really, really slow. It'll be fun to know if the lab have done the testing they're supposed to do, because I believe wasn't they ordered to deliver it to them yesterday or the day before?
I thought so.
I believe it was. Yeah. But the state is really, really bad in this case.
So far, there's one letter that I'm going to need more time on. It's a letter dated May 18th, 2023. The others so far, I'm prepared to let you argue in general terms.
With regard to that May 18th letter, Your Honor, that is not one that I will be.
Okay, that's why I brought it up. Okay, so.
Right. That's why I responded.
I like that Giannetti fella. He seems really competent. Yeah, there are people there, but it's a Zoom meeting.
So you're also not going to reference the response to that letter? June 1st?
Correct, yes. Yeah, those deal with the Office of Professional Responsibility.
Okay, I just have 2 more to just quickly take a look at.
Cool.
So clearly she was able to get copies of them. So why didn't you 10
No, she
million
just
years
got them
before?
she just got them from the state.
Well, yeah. Why didn't they give them to her beforehand? She
Didn't ask for them, and they didn't provide it. So
I don't care. It's annoying.
she does that a lot, especially with. She seems to not like Giannetti, and she seems to not like the female lawyer.
Mm-hmm.
And I bet some of the people who is into it
Right, so I'd also
will know
like
these
some
people.
time to take a look at the June 21st and August 3rd letters. Were you planning on referencing them?
I'm going to reference them in terms of the subject matter, but not the details.
So the letter dated August 3rd, 2023. Do you have that in front of you, Mr. Yannetti?
I do, Your Honor.
All right, so the second paragraph, the second full paragraph, I'm not going to allow you to reference that right now.
Your Honor, if I may, the letter may be visible on the Zoom screen.
I've got the,
Just when you're holding it, you can
see the light can see through it, because I've got the print facing me.
You could see a portion of the print, that's all, just from the
Okay.
angle.
All right.
No, but well,
All right, so
this
with
the
that,
state has a motion to suppress, and the defense has a
parameters, Mr.
motion to
Nettie,
not
I will
suppress.
let
So
you- I will
Well, if
let
they had
Yeah,
a
you
it's a
motion to
Zoom call.
suppress, they
this
should have
subject
provided the
matter
letters,
of
stupid
the
idiots.
others.
yeah,
Okay, that's fine, Your Honor.
in this
So,
case,
in terms
always
of
make
the
sure
two
you
parts
give
of
it to
my
him.
argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cites Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation. And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the
How much are you going to bet she's not going to
They should be unsealed.
make a ruling right now?
But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is, it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently
Sounds like there's
impounded by
fire
this
in
court
there.
as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that, even before the U.S. Attorney ever confirmed that there even was an investigation, And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters.
Yep.
We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right, is there a response from the Commonwealth or no?
No, Your Honor.
Okay, all right, so I'll take this under advisement. I do need copies of these letters, so
I'll take it under
Mr.
advisement.
McDermott can
Of course.
make copies and then hand them back to the Commonwealth. All right, so the second motion is the Commonwealth's motion for Rule 17 for records from Boston Magazine. And I understand there's counsel here from Boston Magazine. If you'd come forward, sir. Hi, you can stand at the podium or council table, wherever you're comfortable. In a minute, I'm going to ask you your name and I'm going to hear from you, but I do just want to state that I appreciate that today
No, she's always,
I did receive a response.
She's always taking it under advisement.
From Boston
Last
Magazine. I
time she did
received
rule in favor of them in
there's
2 out of the
memorandum,
3
there's a
things they
limited
wanted.
Opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity
Again,
to
last
read it
time she allowed
sometime,
2 of the 3
before the hearing.
things they asked
But
for
I
after
do
at
appreciate the response. And more
advisement.
importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, E-R-T-S-C-H-E.
Okay. All right. Could you tell?
Representing MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right. So there is the Commonwealth filed a Rule 17 motion. You, as the third party or the record holder, have a right to be heard. So I'll hear you.
Thank you, Your Honor. There are really 3 documents at issue. 2 recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Reed in the presence of her counsel.
Okay, you say almost entirely on the record. Could you explain that, please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is a interview with Karen Reed alone at her home between Gretchen Voss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that interview appear in the article.
Okay.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2,
okay,
because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Counsel was present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself.
But I thought it was only the turtle riders who harassed people.
Inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay.
And
Oh. So the CB is going to put those in prison too?
She's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
Yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a gold mine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Reed had confessed in her interview with Gretchen Voss, that would have made it into the article. This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape, body language, physical reaction to a question, the same thing. These being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613 of the case that ultimately, when it went to the Supreme Court, became Brandsburg v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by two broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas court said it may be argued that use of newsmen as witnesses is likely to.
This is the paper's lawyer, because they want all of the notes pertaining the interviews she did, but they're saying this is privileged information, so you can't use it. And he's arguing that right now, that the press have certain leeways.
Result in unnecessary or burdensome
Boston Globe.
or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of the matter of John Doe grand jury investigation, to say that this balancing requires balancing between A, the public interest in having every person's evidence, against B, the public interest in the free flow of information, which can be implicated by needless disclosure of sources or confidential information. In that case, Doe affirmed an order quashing a grand jury subpoena issued to a news reporter in a murder investigation where the information sought had, quote, according to the court, low likelihood of benefit to the grand jury when balanced against the public interest in the dissemination of information. That's Commonwealth against Doe, 410 Mass at 602. There's also the Commonwealth against Bowie case from 1995, affirming a trial court order quashing a subpoena issued to a reporter by defense counsel in a murder case. And those two cases, I'd say, are exactly on point. Now, here, Ms. to some extent performed her own balancing test. And after considerable discussion and consideration, she decided to waive her privilege as to the two recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel. I'd submit, Your Honor, that her notes of that third interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements and is set out in
Aiden
her
can't afford this
affidavit.
guy.
Production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear, although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the fourth estate. Now, there's a additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. The petition for the promulgation of rules 395 Mass at 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. And it goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that that is binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So in conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the two audio-recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those two taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right. So is Ms. Voss willing to still provide the 4-hour interview and the 2-hour, the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those?
He's
some redaction
Yes.
needed. I'm not quite sure how that gets conducted.
Okay.
But
he's there on behalf of the journalist who interviewed her.
Okay.
possibly less if necessary.
All right. All right, I'll hear the Commonwealth and then I'll give you a chance to be heard again, sir, if you want. All right, Mr. Lally.
Thank you. Your Honor, the nature or the chilling effect on news gathering that counsel alludes to in the motion in opposition as well as in argument, the Commonwealth would submit is speculative at best. I refer the court to the decisions that are cited by counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here The source itself is not confidential. So we're not talking about a confidential source. We're
Hey,
talking about
Pixie.
potentially confidential
Hey, Pixie.
information. But notably, what's cited to our federal cases, because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion in submissions that there is not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition to cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. So 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17, would ask that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting. Again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that third. I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first 2 recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
Well, we don't know who made the threat, even though Grant is saying it was Turtle Riders who did it.
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said, because Ms. Voss does not oppose the release of the 2 interviews, save the off-the-record portions of the lawyer.
I think he's talking about the 3rd interview.
Yes, but I'd also refer to any part of the first 2 interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off-the-record portions contain, but if they contain statements by the defendant, the Commonwealth would be seeking those as well.
Well, that gets to the next point, really, the distinction between confidential sources and confidential information. And I'd submit that That's a distinction without a difference. The same,
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please
that-
feel free to provide it.
All right. Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena in terms of only wanting statements of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize a common law privilege. They do. They recognize an evolving privilege.
Because this is a different set of letters. This first was to squash the Fed letters. This is to get into what the reporter wrote down during the interviews with her. It's different matters. It doesn't pertain to the same thing.
It's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor, and on the criminal side as well. The question of harassment comes up as part of that test. And it's true. We're not saying that the Commonwealth has harassed Ms. Voss, but she has, in the unique circumstances of this case, suffered and will continue to suffer harassment to the extent that her role becomes large. And ultimately, Your Honor, there's a lot there, and we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Okay. Thank you very much. So you say it'll take you 2 weeks to get those first two redacted and sent in. And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me. I am concerned about the safety of the reporter. She shouldn't have to suffer harassment or any danger as a result of this.
Of course not.
All right.
Counsel,
So,
it's February 1st, which is 2 weeks from today. Is that doable? It's doable.
okay. All right. Thank you. So, Mr. Yannetti, we need to get a date for the remaining two motions that were filed by the defendant, the motion to dismiss and the motion to disqualify the district attorney's office and sanctions. All right, so as you probably know, we're in the middle of a trial that's going to go a few weeks.
You have another date on the 15th of February.
Can you suggest a date?
I can. How about?
May I interject, Your Honor, with regard to a date? I know that our final pretrial is February 15th. Our request
February
will be
15th? I thought it was February 26th.
Nope, 15th and maybe 26th.
15th and February 26th.
Okay.
So you're both right.
Yeah.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15th. And I'll tell you why, Your Honor.
Of course.
One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney, is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did
trial.
they give you a date, Mr. Yannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2 o'clock?
It is, it's at 9 o'clock.
All right. Assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
The only issue there is that I do have a trial before Your Honor that's scheduled for February 13th. So,
Right. That's the case that I expect we'll be on trial for. And if that's the case, we have.
You
to
set the
finish
time
that.
last time,
We've got a very
Lally.
busy
Can't you
trial
remember?
schedule. So if we're on trial, we'll see you at 2 o'clock. All right. So stay in touch with Mr. McDermott. All right. Is that it for today then?
that's it for the Commonwealth. Thank you, Your Honor.
You all set, Mr. Yannetti?
Yes, Your Honor, thank you.
Okay. All right. And Mr. Birchie, I appreciate you being here, sir. All right. Hearing's over. Jim?
Thank you. February 15th.
Okay.
Goodbye.
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 Well,
Uh-oh.
that was interesting.
It was something.
Confirmation that Morrissey is being investigated.
Yep.
The investigation is ongoing. That's interesting. And the feds will be releasing evidence to the defense. They had a meeting today. They will be releasing evidence in the beginning of February, which will lead to the defense arguing that the case should be dropped and sanctions against Mr. Morrissey. So that's interesting. And then the Boston Globe said that the reporter had been harassed like never before. They were afraid that the state was going on a fishing expedition by if they released everything, every note about how she looked or how she was carrying herself. They were willing to release the 2 and 4 hour audio portions with redactions, but they weren't willing to release the handwritten notes because they thought that was privileged information. And the state said, no, we're not going on a fishing expedition. We just only want the statement from the defendant.
All right.
Yep, we believe him. And concerning the harassment of Ms. Voss, yeah, of course, the judge should take that into consideration, but no, don't take that into consideration. Just give us all the notes, give us everything. But they're only after statements by the defendant. But the Boston Globe said you can have the audio from those 2 and 4 hour interview, but they still said there's a question about what is confidential information and an informant, and that the harassment must be taken into consideration. And if you go to I won't call it the opposite side because I don't have a dog in the fight. I'm just an idiot from Denmark. But that Grant guy who's always live tweeting, he said that the Boston the newspaper's lawyer said that it was the Turtle Boy side who had harassed her. The worst harassment ever. I can't. Did you hear that, Jamie?
No, I didn't hear about saying worst ever and stuff like that. I missed that part.
No, but it wasn't said. But that idiot is live tweeting and is lying again. We just had the audio from the last court hearing. You and Dave read the testimony.
Oh yeah, I was.
He lied about that as well.
He's a liar. He's such a liar. He
lies, and he before today he said, "Well, I I'm like a sketch artist. I embellished a bit to give it a little more flavor, and
Yeah.
I wrote, yeah, you're like a sketch artist if you make if you drew them the wrong color, the wrong gender, the wrong hairstyle, the wrong body type, because he's such a fucking Grant.
Mm-hmm.
And Yamaha Biker, hope you're doing well. And Dave has the link, so Dave, if he wants to jump on, can. He probably missed that I put it up for him. So yeah, yeah, I know his mom. I'm not can't off my head. Yes, but yeah, but that he has a press pass and is sitting there pretending to be a reporter, and he clearly lied. He wrote that the lawyer said it was turtle riders who had harassed this journalist. Why would they harass a journalist who's just making an interview with Karen Reed?
Yeah. There would be no reason for that.
It's such a stupid argument that I really don't understand why he could do that. It's
So I test.
it's I don't know what to say, but of course I'm biased. Of course I watch the trial, try to put my spin on it, because or else you could just watch channels without commentary. But why? I would never say that the Fed letter made sure that Karen Reed is going free, because they didn't. The only thing the Fed letters apparently shows is there's an ongoing investigation into Mr. Morrissey. And that's going to be very interesting.
Oh, for sure.
I have said many times, I know a lot of people are saying, well, the feds will clear Karen Reed. I have said many a time, don't believe in abracadabra. Make sure you dot your T's and cross your I's.
Mm-hmm.
And people are saying, no. But of course, I have my biases. But that, I'm sorry to say it, and I don't use hard words enough or often, but that's just idiotic. Sitting there live tweeting, because so many people follow him and believe now that Aiden's crew has been out there harassing a woman. Janette said the feds won't allow this to go to trial. No, they didn't say that. He didn't say that. He said that they had a meeting today with them, and it's ongoing, and they will be releasing the stuff before the next hearing, where he will have his motion to drop the case. Yeah. Tri-fuel generator. Yeah. Shenanigans all over the place. Dot your I's and cross your T's. Exactly, Brian. Self-deprecation doesn't suit you, nor does it fly. Your input is both key and appreciated. Well, but I'm not a lawyer. I have no legal, I only use what I feel is common sense to evaluate the information I get. And I know, and Grant probably does the same, but I try not to openly lie about what's said. I would rather sit here and tell you, if Giannetti had said, well, there's nothing in the Fed letters, I would have said that open and honestly. I wouldn't have said, well, it's going to be, it's not the Feds who run the trial. It's the judge. No, he said they will be releasing it, and they need that for their motion to dismiss. That's what he said. Yeah, he said he needs the information in the motion to dismiss, because whatever comes out, well, let's just do it again, because I'm pretty sure that he just said that he will be needing the Fed's letter to
particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
This attorney is that they notice.
Okay.
We have February 15th and February 26th.
Okay.
This is where he talks about the U.S. attorney.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15. I'll tell you why, Your Honor. One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Tianetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing, probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact. And we probably get this information sometime in early. My expectation is we probably get this information.
Give you a date.
There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Tianetti?
Okay.
I hear it. Yeah.
They did say that it could take a conscience, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Tianetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation.
Thank you all so much. I was wrong. As I said, I would rather listen to it again and admit I made mistakes than sit here and say. But again, that's his that's his information. So. But if that's correct, that's the bombshell people are waiting for. But again, do you trust this lawyer will take that under advisement? I advised at Jamie. What's the word I'm looking for?
Well, do we really think that that's going to happen, though?
I don't trust this later.
That's the whole thing. Is like.
Yeah, it's on Bev. It's on
Don't hold your breath, people.
Advisement, yeah.
Yeah.
My guess, based on that, they have evidence that would exculpate her or incorporate someone else in the money. Yeah, but again, now we're into what have happened to us. Dave is still going on. It's still go. Dave, where is he? Is he live?
No, Dave. It was Dave. That asked a question.
Oh, sorry. The Treehouse trial is still going on. The stipulator is done, and I think they're talking with the DNA expert right now. We'll go back to it, but I just wanted to go through all of that. And yes, they had a conference call with the feds, which was quite interesting. And the feds said, we will be releasing evidence in the beginning of February due to the TUI process. And as I was told, in good conscience, we can't let this go to and then Bev trolls it on.
Yeah.
It's about Morrissey. They said they were told in the letters. No, they were told that Morrissey is under investigation and the investigation is ongoing because of this trial.
Yep.
Well, yeah, Karen has a little more swagger than Tucker. But yeah, that, as I said on X, bombshells be dropping.
Mm-hmm.
Oh, talking about a bombshell. More more of a smexy bombshell than anything else.
How we
There
doing?
He is. There he is.
I heard my name,
Yeah.
and then
Did you hear
I discovered that you actually did have a link for me.
Yeah. Been there all day.
I know. I've been doing Zach Anderson and Crumblies and a bunch of other stuff. Dave.
I figured.
What do you think about those?
Yeah, David.
Well,
give us
I
your
find it.
viewpoint.
I believe the motion to release the federal DA's letters, that's probably going to get granted, especially if it's going to come out anyways. It sounds like there's nothing terribly troubling in them from a legal standpoint. But it sounds very, the way the attorney put it, very embarrassing for the state DA, which is going to be fun to read through. Yeah. And then with the other one's interesting. Actually, it's a very interesting argument. So Karen Reed did an interview, and in the interview that went out public, right, the state can just grab that. The state, it just grab it, record it the way we record stuff, and it's no big deal. But they want all the other stuff that, like the notes and the stuff that was said off the record and things like that. That's very interesting. I'm just thinking back to the Jodi Arias trial. They played a lot of her interviews, but they were televised portions of the interviews. There was no behind the scenes stuff. I would have to imagine that there is a confidentiality rule that would apply, but I don't know Massachusetts law. I don't know if it recognizes that. Very good attorney though for the news media person, whoever it was, that the reporter that didn't want to turn over that confidential information. He was very eloquent. He was on point. He's not like some of the other attorneys we've heard argue in this case, not talking about the defense counsel, mainly the state's attorneys, and how they're all over the place. And they don't even believe in their positions, it sounds like. So, no, it was it was an interesting argument. I'd have to go brief it if I was to make the same argument in Michigan, because I don't know what the law is regarding that sort of thing. The general rule is anything you say to anybody can be used against you, right? That's why you don't talk to not only police, but anybody. If you tell your neighbor can be subpoenaed to testify as to what you told them. And to treat reporters in a special light, given the First Amendment, I think does have a precedence in this country, but it's the nuance. It's the, okay, well, you made a report, but you're not keeping your identity secret, but you did say some stuff off the record. So is that discoverable? It's a very interesting argument. And I want to see where this judge comes down on that. That's my 2 cents.
And Stephanie, or maybe Stephanie, thank you so much for your super chat. Thanks for covering the case. Love your opinions and drawings. Well, thank you so much for that.
I come here for the drawings.
Yeah. Jamie just comes for the nudes.
I do.
But thank you so much, Stephanie. You're going on the board.
My hair's a mess. I just got back. It's snowing out. Jamie, is it snowing by you?
Yeah, it started to. And I got an eyelash appointment today, so it needs to stop.
Oh my God. I found something.
What?
Hang on. Let me find it again.
Please speak to how much of a bozo this judge is. Harassment of the reporter, such an obvious shot at turtles. Well, it's
Why is she always never prepared? Probably has a lot
if
to do
she
with
hadn't,
state, I'm sure, or the Commonwealth.
Yeah, you can say, the defense should have provided her with the letters, the 6 or 8 letters, how many it is. But again, shouldn't the state, because they wanted to suppress it, so shouldn't they do it?
Yeah,
Oh,
they would.
someone drew me a little piggy.
What?
A little piggy.
I'm a little piggy. Brian Fitz, thank you so much for becoming a member. You go on the board as well.
You're a muffin top. Yay.
The little muffin chip.
Little muffin top.
I saw this and I immediately thought of Jamie.
Oh God, what is it?
I turned the volume down so we don't play the music.
I told the volume, and then you play the volume.
Look, there's another one. No, that's my phone ringing. Immediately thought of Jamie. I was like, oh, there's some eyelashes.
But why? I would never. That looks ridiculous.
The nails.
And
You could do the nails.
First of all, I keep them short and nice. Because I don't know how people, not to get weird, but how do you wipe your booty with stuff like that? I mean, if girls have them and you know how to do it, cool. But I don't know how.
I just saw those and I immediately thought of Jamie. I was going to tag her on Twitter.
Well, it looked like me too, Mark. Not only Bev, it looks like me. Yeah, that's pink eye waiting to happen.
Yeah, it really is.
That's a lot. Yeah, that's a lot of things waiting to happen.
It's just, I don't even know how they see. They look like camels.
I know. I don't know how they. You're talking to me. I don't get crazy eyelashes.
Well,
They're
you do.
very
You ask
natural.
for the stripper length.
I do, but at least I can see.
That's not Jamie.
It is you. I feel like you imagine that when I close my eyes, like everything goes dark, and then, or you're not close my eyes. But like
Yeah. No, this is
like
okay.
sitting
So
there.
you're like, ooh,
It's
I
not
look
like
pretty, and then we're looking at you like this lady. Put it back up if you wanted to pull it up. That's how I see it in my mind.
It's not what happens.
But Dave, what do you think about the last statement that that the feds are going to release evidence before the motion to dismiss this trial, because they won't? I don't know if you heard it, but
Feds to the rescue. I heard that. I mean, I don't trust them as much as I don't trust state police. But you know, the enemy of your enemy is your ally, you know, kind of approach. So I don't know.
But it was more Janetti's statement here. If because why would he mention? Come on.
I wasn't listening for the last few minutes because I've been dealing with the media player.
No, because I was yelling at Grant for lying, and then people told me I was lying. So we tried to do it again.
Directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Tianetti?
They did not, but this case bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Tianetti?
Yes, he jumps in right when he says,
in good conscience, they can't allow this case to go to trial without releasing this information is probably where he was going with that. Without providing this information to both sides. That's probably where he was going with it. Not that they're going to stop the trial. First of all, federal courts, federal DA can't stop the trial. Nobody can stop the trial except for that judge right there. But what he was probably saying is, can't let this case go to trial without this information being made available to both parties.
But
That's what I was thinking it was going. That's where I thought it was going.
Is it unheard of that they go in and release evidence from a...
No. What you generally hear about it, though, is you usually hear, and you see it in trials where an FBI agent is called to the stand because the FBI agent helped in the investigation and did testing on evidence that's proving the defendant guilty. And so it's very common for the state and the FBI to be working together, and then the state calls the FBI agent and things like that. What's unusual about this case is that it seems to be the other way around. It sounds like the defense might be calling the FBI agent that tested the evidence and doing things like that.
No, so this is pertaining to the investigation into Morrissey. They had a meeting this morning about the investigation into the police department or into the DA's office. That's what he's talking about. It's not the trial.
Oh, it's not the trial itself.
No, I'll just backnate it a little bit more so you can hear it.
The one thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's
It
an active
is. I
investigation,
would agree.
and they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did they
trial.
give you a date, Ms. Tianetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
Maybe it's some sort of Brady violation. Maybe it's some sort of Brady violation where the DA is withholding exculpatory evidence and not turning it over to the defense, but the FBI knows about it, and that's part of the wrongdoing. That's part of the sanctionable issues. That's part of why this DA's office needs to be recused. Maybe it has something to do with that. That would make sense. I mean, that would make sense as to why the feds would want to release it before the hearing for the sanctions and for dismissal and all this stuff. It could be something like a Brady violation.
If the state dropped it, she would have to sue them to get money. That's not automatic.
Okay. So I will say this, as far as I know, I don't know if it's statewide. I don't know if there's something special in Massachusetts, but in Michigan, if you wanted to sue for a wrongful prosecution, which would essentially what this would be, you have to be acquitted by a jury. You can't do it if it's just a dismissal. Now you can, there's another case or another cause of action called abusive process, which maybe you'd have a foothold in under Michigan law if they dismissed it. But I don't know Massachusetts law, so just take that into consideration. But generally, you have to have an acquittal, not a dismissal.
Does she seem unbiased? Just wondering if I feel. I don't know if she's biased. I just feel she's unprepared, and she won't be caught on camera having an opinion. Because again, last time she did rule in favor of the defense in 2 out of the 3 wishes for phone records. So she's not all the way against Karen Reed, but she seems like she isn't a lot of judges go along with the state kind of judges.
Well, a lot of them come from positions of government authority, like they come from the district attorney's office, or they were prosecutors, or they were brought up within the judicial system. And, the court is a state department, right? It's a state department. So they're all kind of playing on the same side to some extent. And you see a lot of that. And in fact, there's a particular judge locally for me that doesn't play that ball, that makes particularly with warrants. And the police get so frustrated because this judge is like, no, this isn't enough. And he doesn't sign warrants. And the police hate him, right? So why is that? Because they're making them, do their job. Why would you hate a judge? Wouldn't you want a judge that's fair and impartial? But that's not the ones that usually get in those positions. Usually it's the ones that play ball with the state.
And would the feds care about some Brady? Yeah, if they're investigating the department, they would care about Brady.
Well, it might also help
I think.
them prove their case, right? If they're looking at misconduct by the DA's office, and this particular case is just another notch in the misconduct belt, a ruling from the state court that there was a Brady violation and an involuntary dismissal of the charges against Karen Reed would bolster their position if and when they actually bring federal charges against this particular DA and his minions. So to the extent that it benefits them and their investigation and potential charges, yes, they would do that. Or they could do that anyways. I don't know if they would necessarily.
Interesting.
But yeah. So this is all the, I scratch your back, you scratch mine. We're on the same side. The enemy of my enemy is my friend. sort of situation going on right now.
Yeah, and I think it's really weird that the feds are reaching out to them, calling the defense and saying, we will be releasing to both party in this case. So again, I'm not saying abracadabra things or anything, but still, there's more to it now, and that the DA wants to keep the letter secret, but the state, the U.S. attorney said no, we don't care.
Mm-hmm.
That seems like it's not flattering for the DA.
Very interesting, though. Very interesting. And of course, this judge isn't taking anything. She's not going to make a ruling right now. She's going to
It's going to be dropped at 7:00 tonight, like the last time.
Well, the other thing too is that she did rightfully ask the reporter's attorney for some case law, and he said he'll produce it. And so you don't, and that's the other thing too, is you don't necessarily want a judge that issues edicts from the bench right now, because generally they've had their mind made up or they're wishy-washy. I would prefer a judge that would take something under advisement over one that's going to make a decision from the bench. I want them to sit back. They've seen all the written arguments. They've heard the oral arguments. They're now going to take in a couple more cases. They're going to reread everything in light of what they heard, and then they're going to make a decision. This is the judge that you want. You don't want one shooting from the hip. So, yeah, don't trust the feds. They're cops too. I agree.
Yeah, and that's what I say, because there's been a lot of hope in the feds that the abracadabra will happen with the feds, but still, always cross the I's and dot the T's. Don't believe abracadabra happens. It's as we see with Tucker, our Treehouse guy. He believes in abracadabra, just like Brooks did. I just say the magic word and everything goes away. No.
Yeah.
Always make sure you have a hell of a case, and then maybe abracadabra happens. But don't bet on abracadabra.
I got to try to figure out how to make this player work. I got the videos on Zachariah Anderson and there was no sound. So I called the department. They're like, oh, you got to download this player and this and that. So now I got to figure this thing out.
It's probably VLR. It's always that they use because it's a free codec.
This is GOM. GOM?
Call Wilhelmer.
Well, I put it into my video editor and there's literally no sound. It's just a video. And so that's why I called them. I'm like, hey, you sent me video with no sound. They're like, oh, no, you got to put it in this player and it'll work just fine. So that's what I'm going to try to do.
Someone called.
I'm just dealing with Discovery. And this isn't like the first time. This is police departments all over the country. Every time I get something from them, it's like, oh, you got to download this extra player.
But Wilhelmer is asking if you have a question.
Oh, no, you do.
No, I have no question. I just said you should call Wilhelmer and make him help you with the.
I might. If I don't get this working, I might call him. I'll reach out to you if this doesn't work. But it seems something is happening. Where's my sound? I got to figure this out.
Yeah, I think we're gonna jump back and watch the. I passed the guy who talked about how he stabulated, because we know he had normal sized testes for a man his age. And he didn't even cross-examine him, so I don't think there's much in it. Now it's the DNA expert. So I'm going to start from there, and hopefully we'll end before long, because it's almost midnight.
All right, well, you guys have fun. I'm going to jump off and try to figure this thing out.
Okay.
Have you
Bye,
anything
David.
coming up later?
No,
Yeah.
I don't have anything until Saturday. Jody Day. I might do a Turtle Boy stream at some point tomorrow, but I'm not sure yet. I guess how it plays into my schedule.
Okay.
So,
hey, Wilhelmer.
All right. Take care, guys.
Bye, Hammer. Bye, Dave.
Bye.
See you later. Thanks for stopping by. Everyone, if you aren't already, go join MLS, because he plays a real lawyer on YouTube, and he's a smart guy. He knows a lot of stuff. And if you want someone who's good at cleaning up sounds, subscribe to Wilhelmer as well. He is really good at that. But very interesting, short hearing, but very interesting, I would say.
Yeah,
And
can't wait to see what comes.
yeah, I have to go back and try and clip that part out just for that. Oh, and he's praying too. Namaste, Wilhelmer. And let's go back and see if Mr. Tucker is doing better than he did before, because
Probably not. Who's this lady?
there won't be no Stabby Day, this Stabby Day, because it's my birthday on Sunday, so my family will be visiting me Saturday, and I'll be having my Baker's birthday beef bash on Sunday. Thank you so much, Stephanie, for the super chat. Appreciate you even more. Ellie's lying, shocking. The apple doesn't fall. Is it normally the apple don't fall far from the horse? Yeah, it was super interesting compared to the crackheads. But I would say the first 2 days in the crackhead case was really good because we learned so much about crack culture.
Oh,
He
Roger.
came right on in.
Yeah, they was bloody. Came right around, yeah, you know. Uh-huh.
I'm sorry, sir, that wasn't clear. Could you repeat what you just said?
He said,
They came right around. They got to make a turn on the steps, you know.
Oh, I love him.
11:30 Sunday Eastern Standard Time in the morning. Yeah, and about fashion, that's Mo had something to say.
What
You
in
can
the
see-
Canada swap meet heroin urban cowboy?
So I remind you, you're still under oath. That still carries over since the beginning of your testimony.
Someone purposely sewed those two fabrics together.
When Mo can't speak, you know it's
It's a good one.
yeah, sounds like Charlie Brown's teacher who smoked 3 packs a day. Well, he did like to party, which means drink bud, Captain Morgan, and smoke crack.
Yeah.
Everything is always going on, Iris. They started at 1. They haven't been going that long. But let's get back into that, and I'll take a bio break.
What are possible results?
I should start smoking or something, so take a smoke break instead.
So inconclusive. So when I'm doing a comparison to a DNA profile from a questioned item of evidence,
She has
in which I
just
have
been
results
going
that
through
are
all her. I
comparable or
went to
interpretable,
school, and this is what
and then do
DNA
a
is.
comparison to a standard, and sometimes when that comparison's done, the result is it's inconclusive. And this essentially means that I cannot say for certain if that individual is included or excluded as a possible contributor to the mixed DNA profile. So when I'm doing comparisons, I do something that's called a likelihood ratio, which is essentially comparing one event under 2 separate situations. So it's usually the DNA results given if a person contributed their DNA versus another person in the population with those DNA types. So when I'm doing that comparison, if it falls in that inconclusive zone, it'll be a range in which during my validation, it showed that there were some false inclusions and false exclusions when compared to standards. So in that range, I truly cannot say if that person is included as a possible contributor or excluded as a possible contributor.
Based on your training, experience, your expertise in the area, would there be instances where there is no DNA, there is not sufficient DNA for you to come to a determination?
Yes, sometimes with items of evidence, as I said, the DNA might just be too limited, so I can't do any comparisons to it. Or other times, even with a mixed DNA profile, there might be information for a contributor or one of the individuals that makes up that mixed DNA profile that is higher and easily comparable to. And then sometimes there might be a second or third donor that's a little bit more limited in nature and has less DNA types present. And a lot of times that's where the inconclusive comparison will be seen.
For instance, is there automatic necessary automatic DNA on this pen because I'm holding it in my hand?
Not all the time. So DNA, it depends on a lot of different factors that can contribute to DNA being left behind. So it depends on the individual. Some individuals shed their DNA more easily than other individuals. And then on the item, it depends on
Ew.
length of contact. So the longer one holds onto an item, the more likely I'm expecting to see DNA present. If someone touches an item very briefly, it's less likely to see that DNA present. Also, depending on the item, the DNA that's possibly already on that item, as well as the item itself. If it's a smooth item, less DNA usually gets left behind versus a rough item, because rough surfaces will kind of slough off more DNA. So it really depends on many factors.
If a person had gloves on, would that affect the DNA analysis?
Yes, that can affect leaving DNA behind.
And it would mean it would be less likely that DNA would be left or present on a particular item of evidence that you were asked to examine, correct?
Yes, that's possible.
Judge, may I have a moment?
Yes.
Haley, behave.
I seen it.
Did they find the evidence?
Mrs. Lasky, I think you said Mr. Tucker was one of the standards that you received in this case, correct?
Correct.
And there were inconclusive items that you could not include him in with respect to certain pieces of evidence. Is that fair to say?
Some of the items that I did do comparisons to his standard were inconclusive, and I could not say whether he was included or excluded as a possible contributor to those items.
Nothing further from this witness. Thank you.
Okay.
So now he's gonna ruin everything.
Oh my God. What could you possibly, let's see.
Just crime laboratory analyst Oswald.
Okay, got it.
Or analyst Oswald is fine.
Did you get the subpoena that I tried to send?
I don't think so.
Okay, just check. Maybe
Just checking.
Whatever.
He's going on for
Okay,
25
so
minutes.
We just heard the prosecutor go over the explanation for inconclusive results. Now, did you get some conclusive results in this case?
So there was some DNA evidence that I compared the buccal swabs, and he was excluded as a possible contributor to those DNA profiles.
Okay, and would that DNA profile include the knife that was tested in this case?
Is it okay if I refer to the notes for?
Yeah, please.
That's the judge who says yes or no. It's not you.
So I did take a sample from the blunt end of the handle of the knife, and for that, Franklin Tucker was excluded as a possible was inconclusive.
Yes.
So he failed to demonstrate sufficient statistical support for inclusion or exclusion to that item. For the handle of the knife that I took a sample from, Franklin Tucker was excluded as a contributor to that mixed DNA profile.
And he supposedly
Unfortunately,
was the
those are
one
the-
carrying the knife.
Main samples that I took from.
Don't
the,
talk about it
item,
wearing
other than
gloves.
I did take 2 areas from the blade in which I got a complete DNA profile, but that DNA profile had matched the DNA profile from Matthew Bonnet.
And was that a mixed DNA profile as well? Was there somebody else on that blade?
So on area C and D of the blade that I had taken, that was a complete profile. So that was indicative of a single source profile.
That's the guy who was on the line with the
handle
knife.
of the knife that demonstrated the presence of a mixture consistent with 3 donors.
Okay, and who were those 3 donors?
So I did comparisons to standards that were submitted in the case. Rory Wilson was included as a possible contributor to the mixed DNA profile, and then I did the likelihood ratio that I mentioned, which is a statistic to do to give weight to that comparison. And the observed mixed DNA profile is 12,000 times more likely to occur if the sample originated from Rory Wilson and 2 unrelated individuals than from 3 unrelated individuals. I then did a comparison to Matthew Bonnet. He was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is 9.9 million times more likely to occur if the sample originated from Matthew Bonnet and 2 unrelated individuals than from 3 unrelated
Oh,
individuals.
that's
I did the
a
comparison
lot.
as well to Paula Belmonte, and she was included as a possible contributor to the mixed DNA profile. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and 2 unrelated individuals than from 3 unrelated individuals. And then I also did a comparison to John Johnson, and he was excluded as a contributor to the mixed DNA profile.
And Ms. Oslowski, just in layman's terms, because I love the science behind it, but I'm a little bit more of a layman. Would that mean that it's highly likely that Rory Wilson at some time handled that knife, and that it came into contact with both Matthew Bonnet and Miss Paula Belmont.
So since I'm never present, I can never fully say how DNA got on an item, when it got there, or under what circumstances. I can only do the comparison and say if the DNA types could be included as a possible contributor to the mixed sample, and then do a likelihood ratio to that comparison.
Okay. But again, those are the three main contributors I would from what I'm gathering from your report.
Those three individuals were included as possible contributors, and then I did the likelihood ratio to get the statistic for it.
Okay, and what about the mask that you tested, the mask that was
That's
used?
why I dropped it.
So for the mask, let me take a look. So I took several areas, several samples from the mask. So an area A of the mask that I called, which was a area that gave chemical indications for the presence of blood. And this was on the exterior bottom right jaw area. The DNA results was a complete DNA profile consistent with a female individual. And that DNA profile matched the DNA profile from Paula Belmonte. And I did a statistic or the likelihood ratio to that comparison. And the observed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte than from an unrelated individual. And there was other limited data that was not interpretable that was observed in that sample, but was too limited to do any comparisons to. So that was one area.
Stop there.
Then
Just
there was
you
another
weren't on the
area
knife,
that
you
gave
weren't on the
chemical
mask.
indications for the presence of blood. I named this area B, and it was on the exterior right side of the forehead.
No.
And the DNA results obtained from that area demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And then I did comparisons to all the standards that were submitted. Paula Belmonte was included as a possible contributor. I did the likelihood ratio. The observed mixed DNA profile is greater than 700 billion times more likely to occur. The sample originated from Paula Belmonte and 1 unrelated individual, and from 2 unrelated individuals. And then comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate sufficient statistical support for inclusion or inclusion. So therefore it was in that inconclusive zone. So there's no determination can be made regarding the contribution of Franklin Tucker. And then Rory Wilson, John Johnson, and Matthew Bonnet were excluded as contributors to that mixed DNA profile. I then had an area that I called area C, and this was also an area that gave chemical indications for the presence of blood. And this was the exterior left bottom jaw. The DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. Matthew Bonnet was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Matthew Bonnet and 1 unrelated individual than from 2 unrelated individuals. And then Paula Belmonte was included as a possible contributor to that mixed DNA profile. The observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and 1 unrelated individual than from 2 unrelated individuals. I then compared to Franklin Tucker, Rory Wilson, and John Johnson, and they were excluded as possible contributors to that mixed DNA profile. I then took a sample from the whole interior of the mask, and that demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And I did comparisons to the standards that were submitted, and Rory Wilson was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Rory Wilson than from 1 unrelated individual than from 2.
Holy crap.
It would be the guy, Roy Wilson, who is called Detroit. He is already convicted in this trial. He should stop now. Don't ask any follow-up questions. Don't ask, could I have touched it with gloves on, and don't leave DNA and stuff like that. But I can see that's 20 minutes left of this, so he's probably going to say something really stupid. But this is really good for him. His DNA isn't present on anything. Bonnet's is, yeah. Lawyer from Boston News clarified that journalists do have the rights in Massachusetts. This can only be good for Turtle Boy's case. Hopefully, yes. The problem with Turtle Boy's case is the DV charges now. Tucker is involved because board shorts guy said it was him. That's why he's involved. There's no, and that's why they gave him the opportunity to go home with a 2-year sentence for a felony, because they can't prove he was there. But the problem is the way he's been acting. I think still think he's talking his way into a jail cell.
2 unrelated individuals. Comparison of the profile from Paula Belmonte to the mixture obtained failed to demonstrate the sufficient statistical support, so it's in that inconclusive range. And therefore, no determination can be made regarding the contribution of Paula Belmonte to that item or to that area. And then Franklin Tucker, John
Yes.
Johnson, and Matthew
So
Bonnet were
I'm-
excluded as
I-
contributors to that mixed DNA profile.
I'm thinking,
So,
yeah.
Again, just if I put it wrong, please correct me. Now, area A, C, B, the jury's not quite, I'm sure, we're not looking at the same map right here. Would it be proper to say that Rory Wilson's DNA was the high contributor on the inside of the mask?
Borchard's guy apparently was afraid
So for the
and
inside
left
of the mask, he
just
was
as they
included
came out
as a
of the
possible
house. He
contributor,
drove away.
and then I was able to do a likelihood ratio to that. And then otherwise, Franklin Tucker, John Johnson, and Matthew Bonnet were excluded as contributors, and Paula Belmonte was failed to demonstrate the sufficient statistical support for inclusion or exclusion.
What was the likelihood of Rory Wilson?
So the observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Rory Wilson and one unrelated individual than from two unrelated individuals.
And then the rest of the ones the rest of the samples that you had were from the outside of the mask, is that correct?
Correct.
Okay, so that would have been a contributing.
No evidence so
Paula
far.
Belmont and Matthew.
No
Bonnet,
evidence. She was a
They were
victim.
conclusive.
She had her throat
So these were
slit.
areas that
She's
were
a
reddish
drug
brown in
dealer,
color and gave
Paula.
chemical indication for the presence of blood. And then for area A, it was a complete female, consistent with a complete female individual, and it matched the DNA profile of Paula Belmonte. And then I did the statistic, the likelihood ratio. And then the area B was a mixture consistent with two donors, and Paula Belmonte was included as a possible contributor. And then for area 8C, which was a mixture of two donors, Matthew Bonnet was included as a possible contributor, and Paula Belmonte was included as a possible contributor.
Okay, thank you. Now, as far as the inconclusive results, there's a lot of things that can cause inconclusive results. Is that correct?
You don't have to ask about that.
You know, again,
Don't
is
talk about it.
I've
You weren't
heard of
there.
secondary DNA transfer. Can you please explain what that might be?
So secondary DNA transfer is something that would occur. So say that I touched this glass of water, and then the bailiff touched the glass of water, and then we swapped his hands, and my DNA was on his hands. So we didn't have any direct contact, so it was secondary transfer.
Okay, but that's where that likelihood ratio comes in. Is that correct? Where it's more direct, or there's more than enough DNA for the sample?
So honestly, with my DNA results, I can never say how the DNA results got there. I can't say if it got there from primary, secondary transfer. I can only testify to the DNA results that I obtained and then do a comparison.
Would it be more likely if there was more of a sample, say if you had a larger sample as opposed to a smaller one?
It really depends on the sample and depending on the item. So sometimes it might be a really large item, but there just might not be DNA present. So sometimes DNA just isn't present on an item. Other times there could be DNA results, but it could just be too limited. Or there might be DNA results if there's a biological fluid, and sometimes that DNA result will be more prevalent than other DNA that's present.
Now, the prosecutor also mentioned gloves, how that might affect the DNA results. Now, would gloves totally block the DNA, or would it be
No.
the DNA that's on the outside of the gloves?
Don't ask
that you
these
might pick up
questions.
in your-
I know. God.
So wearing gloves, I would expect DNA to not go through the gloves. I wear gloves at my job when I'm doing DNA analysis to try and prevent my DNA getting on an item. But
Yeah,
obviously,
but
it's
don't
difficult
be
to
an
say,
idiot just because you're
what
interested.
DNA might be on the outside of the gloves, depending on if an individual touched other things
Absolutely
and then
no
touched something
Johnson
else.
anywhere.
So it would be difficult to really say.
Right, that would be that secondary DNA transfer with the outside.
That was a good one, Jamie.
Depending on what they touch or if they touch the outside of the gloves themselves.
Okay, so again, go back to those inconclusive results. They can happen for a lot of reasons. And could you explain some of the reasons that might actually happen?
I'm sorry, one more
You
time,
don't
did
want
say
those.
The inconclusive results, why that might happen.
So with the results where I cannot say definitively if they're included or excluded. So obviously, it's possible that the DNA just, when doing comparison to an individual, their DNA might just not be present. And obviously that can be an option, as well as sometimes, as I was saying, there can be DNA that's present, but it could be too limited or not enough to be able
Stop
to see
bringing
the
attention to that
there.
stuff.
And sometimes
Stop
there
it.
can be another high profile that could be overwhelming the
think he-
sample,
I think he
preventing
has-
other DNA from being present. So those
He
are kind
wants
of
to
the
go to
three
prison.
main
Does
things
he
that,
want to
can affect
be in
seeing
prison?
DNA present.
Okay. Again, like if a mixture like that, it becomes hard. And that,
Yeah, but don't talk about that. So,
okay.
because then the jury's going to think, oh, well, maybe they just couldn't find his DNA. But he did it.
Besides the knife that you tested.
Just look through.
Oh. It's just so stupid. Stop drawing attention to it. Stop letting her explain.
So I did
yesterday, before lunch, you were looking at a life in prison. You would have done anything to get out, right? Yeah.
Mhm.
So you took a 5-year plea deal and said I was the other guy at the Treehouse. No, I told the truth, but you took the 5-year plea deal. Why didn't you say that 5 years before? Well, thank you. Nothing further. So my DNA wasn't found anywhere at the murder scene. No, it was inconclusive. Okay, which DNA was found? Paula, Matthew Bonnet, Detroit, and the stabulated guy. Thank you so much. My DNA wasn't present. Sit down.
And shut up.
Yeah.
I did have some clothing that was submitted. There was a dark blue long sleeve shirt. And I tested some areas and took some samples forward for DNA analysis. So there was the inside left wrist that I took a sample from, and that demonstrated the presence of a mixture that was consistent with 2 donors, including at least 1 male contributor. And Paula Belmonte was included as a possible contributor to that mixed DNA profile. The observed mixed DNA profile was greater than 700 billion times were likely to occur if the sample originated from Paula Belmonte and 1 unrelated individual, then from 2 unrelated individuals. I also obtained partial DNA profiles consistent with a female individual from the inside back left forearm as well as the inside front left forearm. And those DNA profiles matched the DNA profile of Paula Belmonte. And the observed DNA profiles were greater than 700 billion times were likely to occur if the samples originated from Paula Belmonte than from an unrelated individual.
Oh my God, you idiots. Just stop it.
No, because the state brought them up, and he testified that he was offered a 15-year plea deal that he turned down, and then he was offered a 5-year. So the state brought it up in front of the jury, and then then you can cross him on it.
And then I also had a shirt, another shirt that was from a Roger Roggett.
Roger.
I had a sample from. So with items that are collected directly from an individual, I can expect to see their DNA types present. So this item was said to come directly from Roger Roggett. So I was expecting to see his types, and there were 2 areas, the back middle right and back lower right. And he was expected to be a donor to that item. And then a complete foreign DNA profile consistent with a female donor was obtained from items 17D and 17E, which was the back middle right and back lower right. And that foreign DNA profile matched the DNA profile from Paula Belmonte. And I did the statistic, and the observed foreign DNA profiles greater than 700 billion times were likely to occur.
That's my goal for the year.
Originated from Paula Belmonte than from an unrelated individual.
What?
Ms. Ostrowski, I'm just going to ask you a few more questions.
Yeah, we thought he was Roger Rabbit.
Now, was my DNA, just to be clear, was my DNA included in anything in this case? Was it actually, included as a nothing inconclusive?
So for the DNA results that I obtained, he was not.
Stop.
There was no sense that he was included as a possible contributor.
Boom, done.
Okay, thank you.
Oh my God.
Another thing.
Then stop.
Their DNA transfer. How often does that happen airborne? Does it normally have to be something you touch or something you come into contact with?
I'm sorry, can you ask the question one more
Can
time?
you have airborne?
What
DNA
is it you say?
transport?
You
Or
have
is
the
it,
right
secondary DNA transfer or
to
anything
shut
like
the
that?
hell up, but you don't have the ability.
It's difficult to say. I mean, if someone spits kind of on an item, then that can contribute to DNA being left behind.
I would imagine that could happen. Okay.
Mama
So
didn't raise no spitter.
if you have something like the knife, right, and you have both victims' DNA on the blade or on that knife, right? Now, could it be concluded that it's highly likely it was used or came into contact with both people?
So once again, my likelihood ratio or my DNA testing doesn't determine that. I can't determine how that DNA got there.
No.
I can tell you that the samples that I took from the blade gave chemical indications for the presence of blood, and then tell you the results I got, and then the comparison to the standards that I obtained.
But would it be highly unlikely that the DNA from one individual could go across the room to another? I'm asking a question.
Well, yeah, but it's.
You're testifying.
But go ahead, finish the question.
Anyway, would it be highly unlikely that the DNA from one item could jump across the room and get on the wall?
Just cause speculation.
She's an expert.
No, experts don't get to speculate, but if you are able to answer.
DNA cannot just move from one item to another.
That's what I was
Across
asking.
them.
Thank you, Ms. Osmond. That's exactly what I was asking. Maybe I didn't ask you for that. Thank you for your time and thank you for coming out today. Done with my thoughts.
Is there any redirect? Absolutely.
I'm waiting for him to say namaste or something. He's just so stupid.
Start over with, you indicated or you testified and mentioned the name John Johnson.
Yes.
Was he excluded from DNA on the knife?
Yeah, he was.
In your report,
Yeah, he didn't do as badly as I thought. He was an idiot, but
so
still.
From the blunt end of the handle, he was the comparison of John Johnson to the mixture obtained failed to demonstrate the sufficient statistical support for inclusion or exclusion for the blunt end of the handle, and then John Johnson was excluded to the
It's just
DNA
like the
results from
Bradley
the
Young
handle
case.
of the
I'm so
knife.
sorry you have to testify here today.
And
You
then
called me, you
the
dumbo.
2 areas on the blade, as I mentioned that that matched
Yeah,
the
he
DNA
married a
profile of Matthew
millionaire.
Barnett.
Okay.
And I can't even get a date.
Just to recap for the jury, would you please recap?
I need to do more crap.
You could. You just need to get out of Denmark.
Could not be excluded from. They came up inconclusive.
Oh yeah, that was
So for the blunt end of the handle
Experts don't
of the
get to
knife,
test to speculate.
the comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate the sufficient statistical support for inclusion or exclusion. So I cannot make any determination to that item or that part of the handle of the knife. Were you asking just about the knife or just all
Just
items?
no, and the other items that were inconclusive with respect to this defense.
Okay, so then area B of the mask that gave chemical indications for the presence of blood, which was the exterior right side of the forehead. The comparison of the profile from Franklin Tucker to that item failed to demonstrate the sufficient statistical support for inclusion or exclusion. And then there was the interior of the mask. Oh, no, excuse me. Nope, not that one. He was excluded to the interior of the mask. To the inside left wrist of the first shirt, the dark blue long sleeve shirt that I mentioned. Comparison of the profile from Franklin Tucker to the mixture obtained from item 11C, which is what I call it, the inside left wrist. It failed to demonstrate sufficient statistical support for inclusion or exclusion to that item. And then I also took a sample from the inside right arm, right wrist, left upper arm, lower back, and lower front of that shirt. And comparison of the profile from Franklin Tucker to that mixture obtained, because it actually demonstrated the presence of a mixture with 3 donors. It failed to demonstrate sufficient statistical support for inclusion or exclusion. So no determination could be made regarding the contribution of Franklin Tucker to that item.
Well, a previous witness did wear board shorts
There is
to the
also
stand.
a pair of black
He
gloves.
did.
And from the right hand outside top wrist, I took a sample and that demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And the comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate sufficient statistical support for inclusion or exclusion, so no determination could be made regarding that item. Then from the left hand inside of a glove, comparison of the profile, well, that first demonstrated the presence of a mixture consistent with 3 donors, including at least 1 male contributor. And the comparison of the profile from Franklin Tucker to that mixture obtained failed to demonstrate sufficient statistical support for inclusion or exclusion. So no determination can be made regarding the contribution of Franklin Tucker to that item.
What are we doing? Stop it. Stop torturing us.
And I believe that concludes the inconclusive comparisons.
So it's safe to say that there was numerous items of evidence that you didn't have a sufficient DNA sample to compare them with Mr. Tucker in this case.
So those are the items that I did get DNA results, but the comparison showed that it was in an inconclusive range. So therefore, no determination can be made regarding if he's included or excluded as a possible contributor to those DNA results.
See,
And
that's
just to make sure you
doesn't sound good.
only received 1 mask to analyze in this case, correct?
Correct.
No scars, no gator scars or anything like that were ever submitted to the lab, correct?
Correct.
You testified with respect to, I guess, the level of DNA on the knife with respect to Mr. Wilson. What was that level?
Do you mean the amount of DNA that was actually present?
Yes.
Okay, so Or do you mean the statistic? I don't know if
The
I got.
statistic,
into-
I'm sorry,
Okay, I was gonna say, I don't
apologize.
think I got into the amount of DNA. So from the handle of the knife.
Yes, ma'am.
So that demonstrated the presence of a mixture consistent with 3 donors, and he was Rory Wilson was included as a possible contributor. And the observing DNA profile was 12,000 times more likely to occur if the sample originated from Rory Wilson and 2 unrelated individuals than if from 3 unrelated individuals.
Now, Ms. Oslowski, if the defendant in this case is alleged to have been wearing gloves at the time of the murder and the robbery in this case, the likelihood that you would get an inconclusive result is a possibility, correct?
It could be possible. I do know gloves, as I said, can prevent sometimes DNA being left behind. But as I said, I can never fully say how DNA got there, when DNA got there. I
Thank
can
you
only
for
just
stopping
testify to
by,
the results
Aaron.
that I've obtained.
Thank you so much for being here today.
May I recross to ask a
Well,
couple
you'll have to
questions?
approach
Well-
the bench here to tell me what the questions would be.
95% of it hasn't been that worth that much. Only the fashion choice and describing the was really good.
Do not recross.
He's gonna do it. Is he allowed to do it?
That's awesome. Sorry to keep you up. I just need a.
Oh my God.
Questions. Do you know how long it was from the time from the time that the crime occurred to when you got the first samples of DNA? The date.
So the offense date was listed as November 17th, 2017. And then I began working some of the items in this case August 14th, 2018.
So we're talking.
And then
And that proves what?
reports for the first submission of items was released in December 7th, 2018. I don't know if that's easier, maybe.
It's approximately a year. Is that it?
Approximately, yes. And that was all the standards and the knife and the mask. And then I had an additional submission of items, and that include the dark blue long sleeve shirt and the gloves that I had mentioned. And that was submitted September 18th of 2019. And then my report was released on March 31st, 2020. I then got another submission of items. The items were submitted on March 18th, 2020 and April 30th, 2020. And my report was June 25th of 2020. And that was the shirt from Roger Rauget. And the buckle swab was represented as being from Roger Rauget as well.
And just one more time, one more question here is, okay, inconclusive means exactly that, right? Can't be excluded, included. It means exactly that, right?
Stop talking.
Okay, thank you.
Stop saying
Because
that.
you just said again, it can't be excluded.
Mm-hmm.
No further questions for the witness, Your Honor. She's excused. Okay?
So my least
Yes, ma'am.
Okay, thank you.
All right, members of the jury, we're getting near the end of our day here, but I do need to ask you to go in the jury room for a few minutes. I'd like to discuss a few things with the attorneys, and that way I can give you some very clear direction for the future.
So the state's gonna rest now?
Agenda.
Judge, I think we're ready to rest.
You think
Okay,
you're ready to
state is
rest,
ready
or
to
you're
rest.
officially resting, or you need a little time to
We are
think?
officially resting.
Okay. Right, so then what does the defense want to do at this particular time?
Well, Your Honor, we'll go ahead and, let's see, tomorrow's Friday. I'm going to go ahead and see if I can get Ms. Paul Belmont, assuming, we are going to file a motion for acquittal. But, assuming that doesn't get it.
Well, file a motion, I mean, that.
I assume it doesn't get approved, but, if it doesn't.
Well, I mean, that would be something that I would be dealing with first thing in the morning. It's.
But could we go in the afternoon?
No, that's not, no, that's not. No, I mean, I can.
I'm not sure. I'm just not sure. I'm not sure the process, Your Honor. I'm sorry.
Well, ordinarily, it is a motion that's made verbally without any kind of written motion. It's ordinarily something that is anticipated, and it's ordinarily a function of familiarity with the case, and so it's not, so it wouldn't be something that I would say we're gonna put the jury off for the afternoon when it's something we can deal with in the morning, and I don't see any unfairness to expect if you're gonna make such a motion again. It doesn't have to be in writing. You can certainly gather your thoughts and have plenty of time between now and then to do it, so.
That would be fine, Your Honor. The only thing is, at that point, we'll go ahead and, I plan on calling Ms. Belmont.
Okay, so has all the groundwork been laid for that? Because that, I assume it's going to be by the Zoom, and I assume that the setup in the, I assume she's still in the hospital. I don't know that.
She is still in the hospital.
So.
Why doesn't he just say, I'm going to motion for a direct verdict, man? He could just say it right now.
Hook up here and whatever.
He doesn't need to fill out 10 pages.
Our technical team.
Ah, Jesus.
It's always the devil's in the detail.
Your Honor, the only detail that I don't have control over is the state. They wanted one of their investigators to be present. Ms. Belmont did actually have a request from the state, if they want to hear it, that she's worked with a few of the investigators at the state attorney's office before. She was comfortable with, I think it was Frank Zamora and Tom Walker. She's comfortable with either one of them. I would ask the state maybe take that into consideration.
So
we'll have one of our investigators at the hospital tomorrow morning, Judge. Is she at Lower Keys Medical?
She's Lower Keys Medical.
Can we see if Carrie's still here? I don't know that he is or he isn't. But
and did Your Honor get the letter from her physician?
No, I didn't. But I'm not questioning that that the Zoom is all right.
No, it's okay. I was curious because I know she said it was sent in.
Okay, I haven't received. My judicial assistant has not provided any kind of email or fax or otherwise U.S. mail.
I know last time it ended up at the state attorney's office. I'll have to see if that's where it got sent.
But that's not going to be a hang up for me at this point.
I wasn't able to get in touch with them.
Yep.
So I'm just concerned that logistically, I don't know.
None of us have been provided with a Zoom link yet.
None of his DNA was anywhere. So he made himself look more like more guilty with the board shorts guy. And I think he ruined his there's no DNA, and he really needs to to land this, and he doesn't know how to ask for a direct verdict.
So that again, it was based on when the prosecution was ended in its case. The only thing I would ask is that for the number or the email of the tech here in the court, so that I can arrange it with them.
Let me ask you this: how long would you anticipate for testimony to be?
I actually don't anticipate it to be that long, Your Honor. I don't know what they're going to do on cross, but I mean, her story is fairly simple.
He wasn't there.
Can you remind me? She testified during the Wilson trial. In what form was that?
That was the perpetuated deposition testimony, and it was a video. I don't know, pretty long video actually, and then the cross-examination obviously was on the video and the redirect, so that was all done through that perpetuated testimony at the Wilson trial.
But it was also for 3 attorneys on the tape, so you guys probably narrowed it down to just the stuff you needed for that trial, correct?
Okay, I understand we can't predict the future. What I'm trying to do is the best I can understand what to reasonably expect tomorrow, because what if Ms. Belmonte is 2 hours?
I do have other witnesses, Your Honor. I've been trying to get in contact with them to tell them, because I actually originally had them slated to run earlier. We've gone a little bit longer, so.
Yeah, because of you idiot.
Because of you. Yeah, Jesus.
Okay, so I think if we try to put Ms. Belmonte on tomorrow morning, we could run into problems. I don't know, if our tech fellow, I would think he'd be available. If not, certainly one of our other members. But is everything going to go smoothly?
Are you going to be on time?
Much as I hate to say this, deal with the JOA motion, deal with the technical stuff regarding any issues about the Zoom, and have the jurors come at 1 o'clock. So presumably at that point in time, everything's in place for that presentation.
But I think that's probably, I mean, I'm with you, it's unappealing, but I see where Your Honor's thinking. We're gonna have the jury sitting waiting for us in the morning while we work all this out.
Yeah.
And I would rather not have.
Yeah, I mean, I'm just, again, trying to be cautious and considerate of those folks. So
He said he will be speaking.
I find out our main guy isn't here, we get someone else. For what kind of Zoom address? How's that equipment working? Have we tested it?
I would agree, Your Honor.
It's just better to
Stop
have that cushion.
talking over the judge.
Just so Your Honor's aware, Judge, as far as the Zoom link, because I have the Zoom application on my phone. If Mr. Tucker or his representatives have that link or that application, they simply send the state an invitation. We can log on here via the court's internet system and join that meeting, but there are certain steps that need to be taken on Mr. Tucker's part at the hospital to get that in the way.
Well, I mean, I like your knowledge and your, your level of understanding. It just, in my experience, things go wrong. Stuff happens. So,
Technology.
what I say is, I'm going to tell the jurors, come back at 1 o'clock. I'm going to tell us to be here at 9. I'm going to hear Mr. Tucker's motion for judgment.
No,
acquittal.
be there
I'm
at
gonna
6 a.m.
Then see if we can, whatever coordination needs.
Well,
to
you
be
better
done.
tell him, Judge, be on time.
Testimony of Ms. Belmonte is as smooth as possible. In
Where's
terms
the
of
captain's sidekick,
presentation,
Mr.
the
Green Jeans?
communication.
I haven't
Then,
Green Jeans.
You can have someone else.
Oh, that's the
available after
tech
her
guy.
line. Other than that, I guess you'll have the weekend to line up whatever else you anticipate, but we can deal with that tomorrow.
Yeah, but
That's the plan.
he hasn't
Anybody
got
have
a standby.
questions?
No, Your Honor, thank you.
No, sleep in the courtroom. These chairs looks comfy. Good night. Sleep there.
Normal. That's the way trials go. You can see what time it is. So it seems to me that it's a good time to excuse you until 1 p.m. tomorrow. We'll take care of what we need to take care of, which is not short. And when you come here tomorrow, the defendant will have an opportunity to present evidence in his case. Once again, I want to reassure you that we're on schedule. We're a big picture. We're on schedule. And so we all thank you for your flexibility, your attention, your patience, your understanding, and your participation as jurors in this case. Remember, follow the cautionary instructions. See you tomorrow at 1.
I gotta go.
Yeah, that's perfect because this is the end.
It's the end.
This is the end, my friend. And yeah. Will there be any more? Yeah, we're starting back up again tomorrow at around 1 on a Friday.
You don't want to watch all of his arguments?
No. No, I mean, I might keep an eye on it, and if anything happens, I might go live.
6 hour time frame on the Snapchat.
Jesus!
Get out of here! I don't want to watch the Millie trial. That's
all right.
That's annoying, but we'll be back in the morrow. And today, before he directs people to me, I'm gonna say goodbye and send you all over to Recovery Addict today, and say hello from me over there. Thank you all so much for showing up. I'm gonna get some sleep today because I'm tired, and I have to cut all that things. Yeah, bye. Love you all.
Your Honor, I apologize.
What exhibit are you referring to?
I'm going to make this 100, Your Honor. 100, because it is 100% correct.
Objection, Your Honor.
Do you see the lawyer's face? Okay, we have to go back and
widower case.
Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
Wait a minute, I need this story time.
Everybody has.
Everybody has.
Everyone has slept with his mother.
If I showed you.
Oof.